with. I want us to first start with the public notice on the release of April 2026 ATP program examination results, and we'll be brief when it comes to the statistics, where we have the criminal litigation 101 being the lowest at 8.4%. Then I'm looking for professional ethics. I believe it is 103. Let me confirm. 105. Professional ethics 105. It had an improvement of 41.7% as indicated in this paragraph. Then LPM managed to record the highest pass rate of 86.3%, followed by civil litigation of 57.6%. Then commercial transaction had a 30.1%, followed by ATP at 30.5%. So these data are very critical because they can even project how the next cohort will appear. So it indicates that since 2025, ATP had been affected by a lower pass rate. This series revealed a criminal litigation effect. Then another projection that we can indicate is that professional ethics, even if it has improved, it still has the lowest pass rate because out of 1,200 students, only 500 managed to pass. So it still requires a detailed analysis over it. Then if you compare with another unit, 108, this commercial transaction, out of 500, only 100 managed to pass. So this is why we analyze this paper, so that we to see the various gaps and where to shift our attention towards the released data. So maybe Albert, on your side, what triggered the lowest score in criminal litigation in your view? What is happening when we record such low percentages?
Perhaps I think it's the integration between the concepts acquired during the ATP classes, or rather preparation, vis-a-vis the expectation that CLE and their markers have. I believe criminal litigation is one of the units which it is mostly, let's say, straightforward to read and understand, but I'm yet to find out the markers' expectations really, because from the coursework, I think criminal litigation is the one that is mostly covered comprehensively, and even looking at the trend with the previous past papers, it has always been familiar. But again, the issue comes with marking, in my view. So perhaps there is a higher pressure that the markers of CLE expect which students fail to meet, and that is the thing that we need to debunk now, because otherwise it's very tricky to really understand. Sometimes you can even lose confidence after reading everything, preparing yourself very well, but again, if it comes to the expectations of the marker, you don't meet. So that is what we need to debunk.
Thank you so much, Albert. And that is the reason why I decided we start with criminal litigation followed by professional ethics in one session. So in my view, I believe that having interacted with the criminal litigation paper, the paper involved a lot of drafting. The paper decided to test students on situations where you could not have imagined you will be told to draft. Okay, so it was testing on the new aspects when it comes to the criminal litigation angle. It has also tested a current affair matter inside one of its questions as compared to the professional ethics paper. The professional ethics paper appears to have relaxed a little bit and decided to test on the cab rank rules at least it tried to incorporate some angles that are still in trial advocacy, and it avoided the previous practical aspect that it had taken back in 2025 November, where it had even tested on concepts of professional misconduct versus professional negligence, and it also avoided the angle on taxation of clients' bill of cost, advocate party-to-party bill of cost. So we can say that we have predicted a certain diversion, but CLE is always unpredictable. So let us jump straight into the question paper so that we have a critical analysis of the same. This is the criminal litigation paper. As always, we will first start by jogging our minds before we answer. So Jen's neighbor John died on 12th June 2025. His family commenced hosting friends and relatives for evening vigil that included overnight sermons, praise and worship. Jen's 13-year-old daughter BMW attended the vigil. Around 11 p.m., she felt sleepy and decided to walk to their home. On the way, she was accosted by Ben, a 19-year-old Form 2 student at a day school nearby. Ben was in the company of Alex, 17 years of age. They roughed her up. Ben had been rumored to be a sex pest, preying on young girls sent to the shop by their parents. He grabbed BWM and clasped her mouth. He rushed her into the bushes and forcibly defiled her. She managed to struggle with him and raised an alarm. Alex had been on watch to ensure they are not caught. BWM feared that Alex too would have defiled her. Coincidentally, Jane was at her gate and was coming to fetch BWM from the vigil. She heard the screams which sounded familiar to her BWM's voice and rushed towards her direction while screaming. Neighbors and the members of the vigil came out and gave chase to the fleeing duo. Alex was apprehended. He was beaten by the mob and then handed over to the police. Alex is arraigned in court and charged. He is then remanded at the police station awaiting some reports. Ben disappears for 2 weeks and is eventually arrested at his aunt's house in a neighboring county. He is arraigned in court and charged. The prosecution indicate that they will be consolidating the case with that of Alex. Detail the process, 6 marks. B. Draft the consolidated charges, and C. What are the likely pre-trial issues that may arise in this case? So maybe I can give you, Albert, an opportunity to try answer so that we interpret directly to see how students will struggle to interpret the same, then we look at the marking scheme, if you're comfortable. Because I'm conflicted, I cannot answer because I'm the one who did the research.
Okay, let me go through it again. I'm giving my thought in a few.
Okay. So maybe for the benefit of the public, I can also try to summarize it as Albert thinks about. So we have a person known as Ben, a 19-year-old Form 2 student. Then we have Alex, 17 years of age. So they allegedly defiled a minor, BWM, and now Alex is arraigned in court and charged. Remember, Alex had been on watch to ensure that they are not caught. But Alex, together with Ben, the defiler, have been arraigned in court and charged. He's then remanded. Okay, Alex is remanded at the police station awaiting some reports, and then disappears for 2 weeks and is eventually arrested at his aunt's house in a neighboring county. He is arraigned in court and charged. So the two are charged. The prosecution indicate that they will be consolidating the case with that of Alex. So detail the process. One angle that I can predict, already some students could have been confused. Detail the process. Which process are you detailing? Is it the process of consolidation of the cases, or is it the criminal trial process? And the question carries 6 months. Then you're required to draft the consolidated charges. the examiner deeply knows that maybe a student forgot to look at the various rules of framing of a charge. Then what are the likely pretrial issues that may arise in this situation? Remember, we have one minor, 17 years of age, Alex. Current affair in the country, minors have burned down Eltumishi girls. Okay. Albert, have you managed?
Yes, I'm through.
So,
Actually, I was listening to two meetings at the same time. Sorry.
Oh, will you be conflicted, Amma?
No problem. I'll try to manage.
Okay.
Yes. So you wanted me to give my opinion
on this question? How could you have approached it generally, so that we start sticking on the statistics?
So generally, from the main issues arising in this question is the issue of ages. I think the examiners were very intentional on describing the age of all the characters, that is from Jen, Alex, and Ben. And then the other issue arising is on how the police or law enforcement agencies should treat the arrested person, especially when they are not yet attained the age of the majority, particularly considering that Alex was arrested first and he was 17 years, and the period it took to arrest Ben, who is 19 years, and the prosecutor's intention to consolidate the case with that of Alex. And from the facts, I think if they are to consolidate the charges with that Alex and Ben, I don't think they committed the same offense. However, for Alex, for the purpose of aiding or being an accomplice to the crime that Ben made, that can be a different charge from Ben. Now, question A is asking us to detail the process. Wait, the prosecution indicates that they will be consolidating the case with that of Alex. Detail the process. So are we supposed to detail the process right from arrest to arraignment, or?
Now, that is exactly what I wanted you to bring it out. Is the question in itself ambiguous?
Kinda, it's somehow ambiguous because the process is very long. Anyway, you see, generally the criminal process starts from when a complaint is lodged, right?
Yes.
In this case, there's this lady. What is her name? Is it Faith? The one who was going back to fetch the BWM.
Oh, Jen.
And she had the screams.
She's Jen.
Yes. Now, in my opinion, here the complaint starts when Alex is arrested, beaten by the mob, and arraigned to court. That's where the police officers record the first entry from the LB that they have received a perpetrator, and they capture the details that they've been given by the neighbors and the mob who involved in arresting. So basically, we can say that is the process of the complaint, right? Because immediately after that, it consolidates complaint and arrest together, because it's not the police who arrested, but again, the public citizens have rights to arrest. There are multiple people allowed to arrest. So from screaming to when the perpetrator Alex is handed over to police, we've done with complaint and arrest. And now from complaint to arrest, we go to the next stage where the police now prepare their file, they take the initial reports, statements, whatever, and preparation of charges, which they then forward to the DPP for their consideration, whether what offense should be appropriate for Ben at that time. Now, this point is tricky because I don't know, the prosecution is intending to consolidate the case on what grounds, because the information that they obtain from the public and the information they obtain from Ben and Alex themselves, I'm sure it will be different. For us, at least, to know the facts. The public might not know who exactly defied the girl. And now here, the police most of the time they listen to the complainant's version of the story. Right?
Yes.
Then immediately the DPP now considers these initial reports and the appropriate charges. The most likely charge that will be preferred against Ben will be that of defilement. That is at least to know from the fact. And then for Alex, since he was on the way, looking out to see if maybe people will be passing by the way so that he can alert Alex, that one you can say he somehow aided or abated the commission of that crime. Then now the DPP can proceed and
Thank you, Albert, for that insightful approach to this question.
Hello. Can you hear me?
Yes, you're audible.
Sorry. There was a technical hitch. I don't know where you lost me.
No, I've listened to the last bit where you are looking at the considerations that will be made by the officers when they are drafting these charges, and you are saying that Ben will be charged with defilement, while Alex will be under aiding and abetting defilement.
Yes. So now, and I was finishing. Perhaps it might that process. Perhaps it might either end there or then proceed, depending on the nature of this that shall be taken, because this question is very open-ended, but perhaps from my end I would have left it at the point they are arraigned to court now with those consolidated charges. Hello?
Yes, Albert, you're very audible.
Oh, yes.
Now,
let me shift my network because I see it's really
okay.
Unstable.
Good. I can see that you could have scored some marks there, because exactly question A was an open-ended situation. Let's now test your application to what we have. So in Kenya criminal proceedings for serious offences like defilement, follow the Criminal Procedure Code and the Sexual Offences Act, together with the Children Act and the Constitutional Fair Trial Rights under Article 50. That is an opening statement. For Alex, who is 17 years old, He was arrested by the mob and neighbors and handed to the police. The police investigate statements from the victim, Jane, witnesses, medical examination of victim using P3 form and post-rape care PRC form, and they even conduct scene visits. Within 24 hours, or with court's extension under a CPC section 36A, he must be brought before a magistrate. Then we have arraignment. This is where he was charged in a subordinate court, a likely magistrate court with the jurisdiction to hear this matter. He pleads. If not guilty, he is remanded in custody because it is common in defilement cases due to the seriousness and risk of interference with witnesses and public discretionary, but often restricted or denied until key witnesses testify. Then there is the remand perspective. So remand while awaiting reports, e.g. medical, age assessment for the victim and accused if relevant, then witness statements. Alex, being under 18, is treated as a child in conflict with the law under the Children Act 2022, and remand remand in appropriate facilities, but not adult prison if possible. On the other hand, we have Ben, who is the principal offender. Similar arrest and investigation process will follow. The police track and arrest him at his aunt's home, arraigned separately initially. Then he takes the charge, he pleads, he is charged, he takes a plea, and there is a likelihood that he is remanded because this is a serious offense and flight risk shown by disappearance because he was found in a different county. Okay, so how do you tackle the consolidation the consolidation aspect that the examiner also intends you to talk about? So prosecution applies to consolidate the cases under CPC section 135 and 36. This is why we have joinder of counts and persons. This is permitted because the offenses arise from the same transaction and facts. This is why we have joint participation in the assault and defilement of the same victim on the same material night. And this form part of a series of similar offenses. So the court orders a joint trial if it does not embarrass the defense or cause prejudice. And in this situation, Alex and Ben tried together as co-accused because we will have Ben being the principal and Alex being an accomplice or aider. Then we will have the pre-trial where we have disclosure of evidence. There is somebody who was not muted. Let me mute. Victor, you have raised up your hand.
Sorry, just wanted to know. I've just joined, so want to know which paper is this you are going through, and for which year?
We are doing criminal litigation 2026 April receipt exam. We were in question number 1.
April receipt. Fine. Which number are we in at the moment?
Number 1. Question number 1.
Question number 1. That is civil.
It's criminal. The question I highlighted before your screen. This one.
That one. That's criminal.
Criminal, yes.
Criminal is 101.
101, yes.
Yes, let me go through it.
Okay.
Maybe you can proceed. I will ask you a question once I've opened my question from this end.
Okay.
I've just opened my question from this end, the paper from this end.
Okay.
Yes, so now you can continue. Say question number 1. 1A or B?
We are at 1A.
1A. Now continue. Sorry for interjecting.
No, it's okay. It's an open system.
Now, I don't know.
Yes.
If you have just analyzed the results which was just released last week.
Yes, we have.
And what were your findings on the same paper?
Okay, our findings were that criminal litigation paper this time, I
Yes.
decided to ask students on
No, I mean in terms of performance.
Okay, performance. Criminal litigation was the least performed with 8.4%.
Yes.
Yes, followed by yeah.
No, I'm just saying similar. What happened?
So for criminal litigation, we have discussed that there is a twist. There is a twist of how the examiner decided now to ask questions this time, because it is full of drafting situations. It's full of drafting analysis, and the draftings are not the normal draftings where students are exposed to. Okay, so it is likely testing on angles that had been quote in quotes and neglected by students.
Yes.
Yeah, so that's how I can phrase it.
Because I was in the same papers from 2015 to 2026. We have just seen that the questions are the same, but we had other findings that the number of those who registered were more than those who sat for the paper, and that contributed to that kind of performance from the expected 100% to 8%. I don't know if you observed that.
Okay, I didn't do a comparison, but that is a good suggestion.
Now you continue, then continue analyzing question one. Maybe you can discuss that later.
Okay, that is well captured, Victor. So we were discussing question 1A, where we were saying that for you to score all the 6 marks, you should finalize by showing the examiner that you understand how consolidation of charges works and what is the enabling provision in Kenya. And in this situation, we had discussed that this is provided under section 135 all the way to 136 of the CPC under the title of joinder of counts and persons. Because in our situation, this will be permitted because the offences arise from the same facts and transaction, and they form part of a series of similar offences. Let me mute you. Okay, Victor, I've muted you because there was a background noise, but if you want to speak, you can just unmute. Hi. So, the second element that the examiner expected to see was that the court orders a joint trial if it does not embarrass the defense or cause prejudice. In this situation, Alex and Ben tried together as co-accused because Ben was the principal and Alex was an accomplice. Then there is an angle of pre-trial where there is disclosure of evidence, possible plea negotiations, though limited in sexual offences. Then there is preparation of witnesses because the victim is a child. Then they will require special protection like intermediaries, where we have closed courts, voir dire for competency if very young. So the process emphasizes speedy trial, victim protection, and chain of custody for evidence like medical reports. So the examiner intended that for you to get the 6 marks, he ought to have seen your input when it comes to victim protection, especially for the child, consolidation of charges where we have joinder of counts and persons, and whether the same applies to this situation, and what about the chain of custody for evidence like medical reports, as we have decided to test the same while Alex was in remand and Ben being arraigned, and the same also following the same situation while under the remand they were awaiting for reports where we have various reports, medical age assessments for the victim and accused if relevant, and witness statements. So basically that was what the examiner expected of a student. So it is not a closed book exam. Any other comment will be greatly appreciated. Then the examiner decided that these students should draft the consolidated charges, and they awarded 8 marks for the same. Okay, so basically this is an extraction of how an actual charge sheet appears, but we are only concentrating on the charges part. So count 1, we will have defilement contrary to section 8.1 as read with section 8.3 of the Sexual Offences Act number 3 of 2006. So that is a mark on its own. Then what are the particulars of the offence? The particulars are that on the night of the 12th June 2025 at exact location bushes near the vigil site in this county, Ben, aged 19 years, unlawfully and intentionally caused his penis to penetrate the vagina of BWM, a child aged 13 years, between 12 and 15 years capacity. Okay. If you have raised up your hand, you can just talk. Now,
with some particulars you have just given.
Okay.
The particulars part. You say that particulars of the offense.
Okay.
You have on the night of. So what happened in the part of the particulars? You should put the name of the accused. Put the name of the accused. So if it's Alex Laruya, you say Alex Laruya. That's in capital. Underline. Then colon. On 17th June, 2025. So if we have the specific location where the crime was committed, you put, like, you can say Nairobi County, Langata Sub-County, then you put the word, you know. You file, then the name of the child, obviously, stationery. The name of the child is written in initial. If the name of the child is written Garuya, you write VM, aged 13 years. So you be specific. If location is not known, we just said at a known place. So maybe if those are the answers you are providing, I think you should do some amendment on that. Be advised, Victor.
Thank you, Victor, for that input. Then I also have a concern. See, also this one carried a mark, the title, because for a charge to exist, there must have been a suit.
No. In the first place, when drafting the charges, we must have the headline. The headline is normally the court. Which provision to prosecute those offences. So we have Republic of Kenya headline in the Chief Magistrate Court of Milimani at Nairobi. Then we have civil criminal case number, and remember that the criminal case number for sexual offences, if it was filed through what do you call this one? The downline system.
E-filing.
The CTS. So it starts with E, then SO. SO stands for sexual offences. SO 041, SO 100, then the year. SO 041 or SO 105 of 2026. Then below that one, we have the parties. Now, the complainant in this case, the parties to criminal proceedings, the main parties are the complainant being the minors in the scenario has been given. So we are going to have the parties showing on the behalf with the Republic being the main party, then as the Republic being the complainant, then we have versus the accused or the respondent, which are there. Then we now come to the charges, and in charges we start the count. We start with the main count. Now remember that for the offenses, the main offenses like murder, or homicide offenses. Then we have homicide offenses, robbery with violence. Those ones, even if the party was assaulted. So we are not going to have the count to being the assault. We just have one count, murder or manslaughter. Contrary, then we have the section. Hope you are getting that. Then
Victor, that is a very critical.
For those two offenses which I have just said, we are not going to have the particulars. We are going to have information. Now, apart from those homicide offenses and robbery with violence offenses, other offenses from stealing all the way down to offense number 20, whatever in penal code, we are going to have the particulars offense. And remember, in the particulars of the offense, we mention we have the accused. Now, if the accused is a child, if the victim is a child, we have tried the intentions. Yeah, you're right. If the accused is on, then you have the debt. The night on. Then you move to the place where that offense was committed. The place you specify after having the date, if you know the exact time, in most cases the exact time when that crime was committed is not known, speculated, and since it's speculated to be, you don't have to write it, so have the date, then you have the specific place. In the start of the county, you can start with the word of that specific village when it was committed. Then sub-county, then county to county, sub-county, then the specific location where the crime was committed, then the age of the party who was involved with the child, and we move to the object which was being used. For this case, it's a defilement. So you say you defile the child VL by causing the penis to penetrate to the name of the child. Hope you are getting that. Any question?
Yes, Victor.
Any question up to that point?
Yes, I have a question, Victor. There is a point that you made that if there is a robbery with violence arising,
yes,
you can't place it
for the robbery with violence the same as murder. You can have two counts. The reason why we are not going to have two counts is that the robbery with violence is going to attract the penalty which can be life imprisonment or death sentence. So those are felonies. But if a simple robbery, it has two counts because the party might have used the food points and called the assault to the other party. And remember the robbery violence, what happened in that case? we are going to have the use of force and taking out of the property. So we are not going to have stealing. This robbery is violence. We are not going to have the stealing the party, using the force, using deadly weapons, then did the owner, the rightful owner of the property. Then at the same time, steal. So we are going to have the assault and stealing. Hope you get that. The same day to defilement. We are not going to have rape, and then we have the defilement. Now, the other thing which I've just remembered to remind you is that when you're going to have several counts, whenever you have several counts in any charge against an accused person, they should not be more than 11. The maximum usually 12. So if it goes past 12 charges, and the charges are not going to run concurrently, then if the charges are going to run consecutively, then you'll find that if the charges are 15 and the penalties runs consecutively, that is, after finishing the term for one count, you move the next count. For example, if we are going to have an accused being charged with 15 count, one count having 10 years, then 7 years, another 3 years, another one, with the average of around 5 for 15 counts. That will take you to around 75 years. So that's the main, that will be the reason why these counts were reduced to around first level 12. Hope you get me for that. So, anytime you come across the question which attracts counts more than 10, you be careful of that and to draft all those charges to be more than 12, sorry, as provided for in the CPC. I'll just give you the main section which stipulate that one. That's on drafting of the charges. Can't remember which session, but I'll go through it, then I'll share with you. Any question up to that point?
Victor, that is well captured. What about a duplexity of a charge?
Duplexity, as I had explained at the time, these are situations whereby while drafting the charges, you have two offenses being carried out or being stated or being charged in the same count. Duplexity comes in the situation whereby in your charge you have two offenses being drafted, and that will result in effectiveness of the charge and charges you are presenting before your prosecutor or before the court. Is that okay?
That is very well captured, Victor. In what situations can courts decide to amend a charge sheet?
Remember that during once the case has been presented to court, that's what means that the process of this first investigation has stopped. The process of investigation is continuous. And remember that since it continues. Sorry. If it's continuous, the charges and charge sheet are subject to amendment. Since they are subject to amendment, several issues which happen with the charge sheets, the evidence and the charges will be amended, and again those will force the prosecution to present them before the court and before the accused whenever any new evidence is being adduced. And remember that when amending the charge sheets, what should be put into account is Article 50 of the Constitution. The whole of Article 50 from me to the last part.
Thank you so much, Victor, for that. Thank you so much. So Victor has taken us through the drafting aspect of it, and maybe many students who have lost many marks are passed to that exercise because it carried 8 marks, and we believe that if you failed maybe to make reference to a certain provision of the law, then you could have ended up scoring less marks. So question C also decided to ask students to give reasons or various pretrial issues that can emanate during the pretrial conference of this case. And briefly, we wanted to analyze the same, where we have the medical and forensic evidence, because we have to complete and check the admissibility of a P3 form, a post-rep care form, and any DNA or semen analysis, and that delays in examination or incomplete forms can weaken the case, and chain of custody issues can arise. So that is a likely pretrial issue where the court will ask the party whether they have complied with. Then to age determination, what is the proof of BWM's exact age from the birth certificate, school records, and medical assessment is crucial for the specific penalty tier. Challenges if documents will be missing at this point. Then 3, we have victim and witness protection and testimony. By the fact that BWM is a minor, voir dire for competency can be used, use of intermediaries, and closed court sections pursuant to the Children Act and Sexual Offences Act. And this is where they will test the trauma, fear of testifying, or inconsistencies, because she feared Alex too, from the fact sheet. Then you have bail and remand decisions. The defense may apply for bail, and the prosecution opposes due to the seriousness and potential witness interference and the community outrage. Okay, one of the compelling reasons that you can be denied bail is for your own safety and security. Remember, these people were facing a mob injustice, so the court can decline. So that is among the reasons that among the issues that will arise during pre-trial. Alex and Amina may argue for different treatment.
Before you move to the scenario again, I'd like you to mainly remind you on what is trending on the social media. Again, concerning the Tumishi Girls incident and the expected orals from July. I hope you have seen that we expect either in orals or in the CRE exams in November, December. These questions are likely. We are going to have the trial issues being retraced again after the April visit. Now, when we say pre-trial issues, these are the issues which mainly comes before trial. It mainly comes immediately after the accused has taken plea before the court. And hope you remember all the pleas which we said last when we were going through all the pleas, when I had explained to you all the pleas which we do have. Now, after taking the plea of any form of the plea, the next thing which usually happens is that the accused person is being supplied with the witness statement, with charge sheets, and the evidence which the prosecution intends to use against him in the court. So, again, we are going to base our law, the legal basis, on Article 50 in that case. Now, sometimes we may get our accused person being was being armed or was being acted as a result of the mob. So the main issue which will happen in that case, immediately if the accused person raise that issue, the court will direct that he be taken to hospital for medication before trial starts. Again, that's under the Bill of Rights. You may sometimes get the court asking the accused if he's ready to continue with the trial, with the hearing process. If he's not ready, then court can give him time to go and prepare. That's again based on Article 50 of the Constitution of Kenya 2010. So those are the main pretrial issues. Sometimes for the case of murder. Usually, again, let me remind you that for such cases, if the accused said that he's guilty, indeed is killed, the court will not record the plea of B or N GE, plea plea of B or GE, plea of guilty. It's court is not going to enter that plea. That kind of plea which court is going to enter is plea of not guilty, even if the accused plead to be guilty. Now, immediately after taking that plea, either guilty or not guilty, then that accused will be taken to hospital. One, the main reason for that is for psychiatric assessment. Court will order the accused to be taken to the hospital to the psychiatrist. The reason for that is determined his competence to stand trial. Remember that the competence to stand trial mainly comes in two forms. One is capacity. Two, and the second one is on the mental state. The accused must be fit. The accused must have the capacity. Now, capacity, as we said, comes in when an accused or a party is of age. The age of majority, that's 18 for the case of Kenya. For the US, is 21. So the capacity differs from one jurisdiction to another. And in this case, since we are dealing with Kenya, the capacity will be the age of 21. So if a party, like our case of Utumishi girls, the 8 accused, the 8 Utumishi girls are below the age of 18. So those parties from Utumishi will be subjected to FOIA dire statement. The FOIA dire in this case means that the court is going to ask the Utumishi girls or the parties from Utumishi some questions, mainly to determine their capacity of understanding what happens or what is happening in court, or what has happened to them, why are they there. So if this party, this accused, will answer the question well, that will mean that the court will presume that the parties, the accused, are competent to stand trial. Hope you get that. The other factors which happen in pretrial, or the other main pretrial issue, we have to have spoke of the competence, the witness. The witnesses seek to be protected, and you may get that sometimes. Some witnesses are being forced to record statement, so that they have to be considered. If they're being forced, then with the leave of the court, those kind of the witnesses are going to be dropped. Then the other pretrial issues are the statement of the accused. We usually call it the cautionary and charge statement. So sometimes, since the investigating officer, since the one recording the charge and cautionary statement, not unless he or she is above the rank of chief inspector. And the charge and cautionary statement are usually recorded by other person other than the IO. The IO in this case means the investigating officer. So after recording the charges, the accused will say, yes, I did, yes, I'm guilty, or no, I don't know. So if you forced the accused to sign anything by saying it is true, and he lies with the name of the court, that again can be dropped, and that constitutes the pretrial issue. So we have to consider all those. Last time I checked, there were over 30. It was around where my laptop is. I could just read to you all these likely pretrial issues which the court may take into account. Then we can narrow down to the parties you have been given in this scenario. Now, when it comes to the scenario, maybe Victor, you can continue by giving us the 8 scenarios which you have just listed from that, and upon that, you have taken down whatever I have said. Victor.
Thank you so much, Victor, for that insightful and very educative remarks. As you were talking, I was also confirming from the social media because you have raised a very important angle. Maybe the examiners are setting the examination that will be sat in November today. Okay, so in that situation, we can't ignore various aspects when it comes to a child who is at conflict with the law. So I decided to project what I have here. Let me download it. It is known as A Prosecutor's Guide to Children in the Criminal Justice System. Victor, now I know this is the document maybe you could have been referring to. This is from the office of the ODPP.
You can project the document, then we can go through it together. That document will help all of us in preparation for the oral, in preparation for the CRB, and in preparation for being prosecutors in come the year 2027. When we are preparing to prosecute the children cases or to come in as the children advocates. Thank you for that. That will really guide us. I'm praying that you take us through that document, since I can see the document is not that big.
Yes.
Yes, the document is around 30 pages.
Yes, we can go through it in a summarized manner, provided we touch on the key aspects that the examiner can expect us to know.
Yes.
So one, it is important to have a look at the table of contents because we will have a summarized the flow of it. So at the table of content, we have the general guiding principles on child justice, where we have the best interest of the child, right to representation and legal aid, protection from torture, participation and right to be heard, deprivation of liberty as a measure of last resort, promotion of dignity and worth, protection from discrimination, right to privacy, and right to parental care and parental participation in proceedings. Then if you look at part 2, we have guide to prosecuting.
Part 2. Let's go back to part 1. From 1 to 9, all those are being provided by the article, which I started on. I was explaining the case of Alex in the scenario you gave. The Article 50, which provide for all those. That's from the issue of the best interest of the child, and we these documents going to guide us on what is being meant by the best interest of the child. Or those parts from 1.1 to 1.9. Now you can proceed.
Thank you, Victor, for those pauses because they are linking the document to what we were tested previously and what we can be tested in future. So part 2 of the same document will reveal the guidance to prosecuting children in conflict with the law like us, we are in the current situation now with Utumishi girls. So this is how we handle children in conflict of the law when we have pre-charge stage, where we have investigations, confessions, use of initials, age of the child, making the decision to charge, and complaints on violations of the rights of the child.
Now,
Okay, so this document, okay.
The 2.2, the all of 2.2 on the pretrial charges is what I've just explained some few minutes ago before you presented this document. From investigations, confessions, use of initials, and remember that they mainly dwelled on the use of initials. Use of initials when the child is when the child is an accused or when the child is a complainant. When the child is a victim, we normally use the initial. Sorry. Now, the CLE paper for 2025 November, it tested on all of 2.3. That's from the provisions of legal representations, alternative prosecution, rights of diversions, bail and bond, and pre-trial conferences and detention. So if you can come across that paper, the 2025 November, tested on the pre-trial stage. Sorry, on those stages I've just mentioned, the pre-trial on 2.3. Now, continue.
Thank you, Victor. 2025 paper is amongst the papers that we will discuss because it has the highest and the lowest performed papers. In our endeavors, we also seek to criticize or critique the highest performed papers to the best standards as much as possible. So that is 2.2, pre-charge stage. Then we go to 2.3, where we have the pre-trial stage. This is where we have provision of legal representation, appointment of guardian ad litem, alternatives to prosecution and trial, bail and bond, pre-trial detention, and pre-trial conference. Then we have the trial stage. This is where we have application for priority hearing, then procedural requirements during trial. Then you have disposal of cases and the role of the prosecutor in disposal of such cases. Then you have post-trial stage, revision and appeal. Then part 3 of this document provides for the guidance to handling children in contact with the law. This is where we have general provisions on protection and care file, protection of privacy, supporting children, application for priority hearing, no plea bargaining in sexual offences cases. And 3.2, we have the pre-trial stage, where we do preparation for trial. And then 3.22, we have vulnerable child victims and witnesses. And then you have the trial stage. This is where we have the plea taking stage, the victim representation and participation, voir dire, taking evidence of victims of tender age, use and role of intermediaries, and victim impact statements. Then you have post-trial stage. We will analyze the role of the prosecutor post the trial, the role of the prosecutor in disposal. Then you have part 4 on register, monitoring and evaluation and review of the guide. So basically, we have the introduction, register of children cases, monitoring and evaluation. Now this applies to the administrative powers of the prosecution. So this is a very critical document that we can not fail to have a look at it in details. So we will begin, but very briefly, on the general principles. So the best interest of a child is provided for in the Constitution and the national legal framework and international child rights. So basically, the principle must be interpreted on a case-by-case basis. So we are only extracting the key takeaways. So given the vulnerable nature of children, the best interest can be easily overlooked if not specifically highlighted. Then there is a right to representation, legal aid, and legal assistance.
Before you continue,
okay,
let me take you to the best interest of the child, what that one means. When we say the best interest of the child, the court is going to look at what the child wants. Secondly, the court is going to look at what is good for this child. Now, let me go to the first point. Is as children a civil case? A child is going to be asked if the two parties are in conflict, that is the mother and the father in conflict, or they're differing on the issues which are before the court. The child is going to be asked who does he want to stay with the mother or the father. Now, if the mother, that is the outcome of what is known as the best interest of the child. Now, for the issues of education, for instance, if the child is being taken to school, any school, that's what is going to be concerned, the best interest of the child. That is both for the good and for the benefit of the child. So in such case, we look at the alternatives. The court is going to look at the alternative. The court is going to look at the predictions of the outcome. So in such a case, the court of the prosecutions is not going to make any assumptions, but the court and the prosecutions are going to choose the alternatives. The court and prosecutions are going to predict the outcome, which is going to consider that it's going to benefit the child, regardless of the parties who are involved in the conflicts. Now, if a child in this case is in conflict of the law, the court is going to consider the best way, the best penalty is going to help that child. That is what is being considered to be the best interest child. And that again is being provided for by article, by us. I can't remember the section of the Children Act, but the Constitution provides that. The Legal Aid Act provide for that. The Children Act provide for that. Those are the legal basis. I can see you have just highlighted the Article 43 of Convention of the Children's Rights. That's an international instrument on children. Article 52H of the Constitution, Section 43 of the Legal Aid Act, 43.3, and Section 77. Sorry, yes, that is it of the Children Act. For the case of the right to representation or legal aid and legal aid assistance, in such a case, whenever a child is in conflict with the law, child has the right for the legal representation. Child has a right for his parent to be present whenever a settlement is being undertaken during the process of investigations. That's the system. That is it.
Thank you so much, Victor. So you have discussed the two general principles on the best interest of a child, and you have discussed on the right to representation and legal aid and legal assistance as it has been provided under Article 52 of the Constitution, Section 43.3 of the Legal Aid Act, and Section 77 of the Children Act. So the other general principle, we have protection from torture. So this situation is where we have any child within the criminal justice system, either a child in conflict with the law or a child in contact with the law, either as a victim or a witness, must be protected from torture or other cruel, inhumane, degrading treatment or punishment. Further, they should not be unlawfully or arbitrarily deprived of their liberty. This is as read together with Article 53(1)(d) of the Constitution and Article 37 of the Conventions of the Rights of the Child. Okay. Then this principle not only denotes the prevention of harm to the children, but also encompasses other core principles such as child development, best interest, non-discrimination, and child participation. Therefore, prosecutors in children cases have a duty to adhere to the principle when handling children matters. Then there is the right of participation and right to be heard. Okay, so prosecutors should protect this principle in practice by the following: allowing the child to speak, ensuring the views of the child are taken into account, and then ensuring the child has the necessary information can intervene and freely express his or her opinion. Okay, so we are basically inclined to the practical element of it because we are going to tackle CLE. Then deprivation of
Let me remind
liberty.
us of this thing that
Okay.
during the participation and the right of the child to be heard. Participation means that the child has to participate during that process, during the trial process, and the child must be heard. So you have stated that. So in during this process, the child must not be forced to participate. The child must not be forced to participate. Participating, I'm saying, is speaking, giving the evidence of what happened. So he or she should not be forced to give evidence on what happened. So it should not be compelled. That's also being provided for by by the Constitution and the other international instruments, which Victor, you have just stated. And sometimes, just like the other witnesses, a child can be the factor of the witness, or the child can be an hostile witness. So, prosecution must take appropriate measures to ensure that during such case, child have to be protected. And the protection comes in by one, ensuring that during the trial, the child should not, the child trial should not take place in the presence of other parties in the court. That's in the presence of, that's in an open court. The child trial can take place in chambers or open court, but no party should be allowed to be in. And if a child is witness, he or she must be protected in the witness box.
Thank you so much, Victor, for that comment. We were discussing on participation and right to be heard angle, and we have directly analyzed the same. Then we have deprivation of liberty as a measure of last resort. The deprivation of liberty of children should be a measure of last resort. Provisions should be made for restorative justice, diversion mechanisms, and alternative to the deprivation of liberty. However, where it is necessary, then the same must be for the shortest appropriate period of time. This is provided for under Article 53 1F Roman 1 of the Constitution of Kenya. Okay. Further, the children should be kept separately from adults in facilities that take into account age and gender, pursuant to Article 53 1F Roman 2 of the Constitution of Kenya, including intersex children and mental disability. Fundamentally, any programming on justice for children should be built on informal and traditional. Any programming on justice for children should build on informal and traditional justice systems as long as they respect basic human rights principles and standards. All competent authorities that hold children within the justice system must ensure that their basic needs are taken care of and that the same is reviewed periodically. That is pursuant to Article 25 of the Convention on the Rights of the Child. Then we have another principle known as promotion of dignity and worth. A child must be treated in a manner that is consistent with the child's sense of dignity and worth that makes them feel valued and respected, pursuant to Article 40 of the Convention on the Rights of the Child. This principle must be upheld through the entire process when a child is within the justice system. Respect for the dignity of the child also requires that all forms of violence in the treatment of children in conflict with the law must be prohibited and prevented. Pursuant to Committee on the Right of the Child and General Comment number 10.
Victor,
Yes.
before the promotion of dignity and worth, like on the privation of the liberty as a measure of last resort. If I just want to bring this information before you, that will be informed. One, that all police stations currently don't hold children in cells. There are some police stations which have a child protection unit. These child protection units are meant to provide for this. They're meant to ensure that children are not taken to cells like the adults. They are meant to ensure that these children, when they're being their liberty is being deprived, in a way, they stay look like they are staying in their homes. So what I wanted to bring into your account.
Thank you so much, Victor, for that. Thank you so much, and we appreciate how you are linking the situation, the ground, to the theory part of it. Then you have protection from discrimination. All children who come into contact with the criminal justice system must be treated equally and protected from all forms of discrimination. This is provided for under the Constitution of Kenya, pursuant to Article 27 of the Constitution, and the Children's Act, pursuant to Section 5 of the Children Act, together the UN Convention on the Rights of the Child and the African Charter on Human Rights, on rights and welfare of the child, which prohibit discrimination on the basis of age, race, color, sex, language, religion, political or other opinion, nationality, ethnicity or social origin, property, disability, birth or other status. At every stage of a child's contact with the criminal justice system, thought must be given to the child's circumstances. All their rights must be protected and upheld. They must not be deprived of an opportunity to access education and health services. They must be offered appropriate services without discrimination. Then we have the right to privacy. The right to privacy is guaranteed by the Constitution of Kenya, the National Legal Framework, pursuant to Section 1976 and 186 of the Children Act, and international child rights instruments. It is a fundamental right that must always be upheld during and after the trial process, whether the child is in conflict with the law or in contact with the law as a victim or witness. No information shall be published that may lead to the identification of a child in conflict with the law, or a child in contact with the law as a victim or witness. This is because any failure to protect their privacy may expose the child to stigmatization and danger. It is therefore the duty of all professionals within the criminal justice system to ensure that all proceedings are held in camera unless there are clear reasons it is in the best interest of the child that is the same be in public. And we are currently seeing the Utumishi situation, where we have never been shown the exact faces of these children. So that is maybe one of the angles that the examiner was expecting to come out clearly during the pre-trial stage. Right to parental care and parental participation in proceedings. The rights of a parent or guardian are not extinguished when the child comes in contact with the criminal justice system, either as a child in conflict with the law or a child in contact with the law as victim or witnesses. This right must be protected at all times during the proceedings so as not to occasion any injustice to the child and also to reassure the child. Now, we are now approaching the various stages that these principles will be applicable. Guide to prosecuting children in conflict with the law. How do you handle children in conflict with the law? The prosecutor will work with the children officer to establish if the child is in need of care and protection as provided by Section 119 of the Children Act. So this requires that the prosecutor should ensure that throughout the trial process, a child in conflict with the law is handled in a manner that is appropriate to the child's well-being. This is pursuant to Section 187 of the Children Act. When the prosecutor is of the view that a child in conflict with the law is in need of psychological support, then the prosecutor should make an application for the court to appoint a counselor or child psychologist at the earliest opportunity. Then you have
that for now, that again. That again, that part very important. That's in handling children with the conflicts. And very important step which bring in the role of the prosecutor, the role of the children officer, and the role of the counselor into the criminal justice system, specifically the court. And remember that throughout the trial process, from pre-trial to trial to up to the last stage in the process of the court, the three parties play an important role, whereby these children, the children in conflict the law mean that a child victim or the child accused. So the prosecutor must ensure that the process is meant for the best interest of the child's well-being. And the prosecutor in such a case must ensure that this kind of children, they must ensure that they understand all the processes. If he detects at any stage that the child is facing some challenges, he must apply to the court. Remember, it's the prosecutor that applies to the court that the child be provided the prosecutor with the counselor. And it is not the children officer. Remember this, it is the counselor. So the three parties mainly facilitate for that process. So this stage of 2.1 is very important. Handling children. So the parties who handle the children network are three: prosecutor, children officer, and the counselor. So whenever prosecutor is handling the children before the court, he must handle them in consultation with the children officer. He must work with the children officer. That is, they work with the children officer mainly to establish if the child is in need of care and protection. So that is the reason once or whenever the children are being arrested, like the Tunisia girls, when they are being put before the police station, they are not being booked with offense of arson, with offense of murder, but they are being put in with the need or being children in need of care and protection, meaning that they have to be protected. So when they are being put in the police station before they are being taken to the children protection unit, what is being done in the OB is children in the need of protection and care. Then the police officer takes their names only, and the children protection contacts which they are being taken into. And as I said earlier, most police stations have these units. So if the police station don't have this child protection unit, they will take those children to the jurisdiction which have such. And if you can look at the one for Tunisia, they are being taken to a court in Naivasha, then transferred to Nakuru Children and the Minor Home. That is where we have a community. So, finally, if I hand over to you, we must put into account that the parties who handle the children involved with the law before the courts are three: children officer, who help the prosecution, the prosecutor, and finally, when the prosecutor will feel that there might be some things which affect the child, he refer that child to the prosecutor, to the counselor, through the application of the leave to the courts. You can move to the next part of Victor.
Thank you, Victor. Because CLE can decide anything, how should you make this application? Is it, or when it comes to the criminal litigation paper, we don't look at the format of it? We just do a notice of motion.
Prosecutors, the application which they make before the court are usually oral application. The oral application. That's the main application. Usually, prosecution next to the courts. But remember that they make this oral application with the help of the children officer, who establish that the child need care and protection. So I've just mentioned to you the Utumishi incident. You remember it was the children officer who informed the prosecutor that these children need care and protection, and they were not to be taken to the children protection unit in police station, but they ought to be taken to children and remand home.
Wow.
So altogether, there's a difference between remand home and the children protection unit. So they might have had the reason for that.
Thank you so much, Victor.
Might have established that these children they need a critical care, so that if they were to be taken to children protection units in police stations, they were going to be affected more, unlike the remand home, the children remand home. And that was the reason why they were being taken to the Naivasha don't have the children home, and Naivasha don't have the children protection unit. That was why they were being taken to the jurisdiction which has those facilities. You can now proceed.
Thank you, Victor, for that. You have even given us the exact situation, what was happening, and the different kinds of transfers that happened. Pre-charge stage on investigations. Prosecutors should enhance collaboration and proactively work closely with other agencies such as the National Police Service, Department of Children's Services, and the Probation and Aftercare Service to guide the investigation of cases of children who come into contact with the criminal justice system. The prosecutor shall request to be notified by investigative agencies of any arrest of a child or when an investigation involving a child has commenced. That is pursuant to Section 27 of the ODPP Act and Child Offender Rules, 5th Schedule of the Children Act. So maybe, Victor, you have an insight?
Let me again inform you that, as I said, the investigation process is continuous. So long as the trial stage has not been closed, so long as the submissions of evidence have not been closed. Now, for the case of children, the investigation being pre-judge stage, the investigation stage involves the stage where evidence exhibits are being collected, so that it can link the crime which a child has committed to what is going to be the charges are going to be preferred against the child. So in such a case, the main parties who are involved again in this stage are three. One, we have the police officers who are going to be the investigating officer. They carry out the investigation of the child, and this investigating officer is going to inform the courts through prosecutor on the charges which the child is being referred to. And the investigating officer must also involve the children officer. Sometimes, once after getting to the court, and it's found that this offenses which the child has committed ought to undergo the course of the community service or probation. These children are going to be taken to probation hostels. That's our measures which we are discussing. So that will bring us to having the three parts, the probation and aftercare officers being involved in the investigations, the children officers, and the police officers. All the three agencies are involved in the investigation process in the third stage. So
Thank you, Victor, for that.
continue.
Thank you so much, Victor, for that insightful comment. So basically, we have seen the various agencies involved. Then the prosecutor should notify investigative agencies of the need to conceal the identity of the child in conflict with the law. The prosecutors should encourage investigation.
That point number 5. Prosecutor should notify the investigative agencies to conceal the identity of the child. To conceal the identity of the child means that you hide the name, use the initials. I remember when I mentioned to you, when I told you that if the child who is in conflict with the law is Victor Ngaruya, you put VN. V to stand for the V, Victor, and that's N for Ngaruya. So that comes from the prosecutor who advised the investigative officer when drafting the charges and charge it to ensure the protection of the child, to conceal. Conceal means to hide. Then, mainly after that, the prosecutor should encourage the investigation officer to use questioning to elicit the evidence of the exhibits by ensuring that the privacy of the child is being protected. If it's a case of defilement, the time of the words which you cannot mention before the child. For some words which is going to make the child to be embarrassed. So whenever questioning a child, if a defilement, use the neutral words like sleeping within, if the child was being raped. You don't mention that word because they look harsh. Use define the lighter word, the neutral word, which neutralizes the harsh act. Victor can continue.
Thank you.
And
Thank you, Victor, for that.
Before you continue, earlier on you had mentioned of the post-care reports. Remember, post-care reports is going to form part of our exhibits. When they form part of the exhibits, post-care report in this case replaces P3, the medical examination reports. They're being filled at the hospital by the medical officers on what they observe, the management they have taken, and any other medication they have given. So what they observe is what they observe when the child gets into the hospital, when the victim gets to the hospital, what they found. So if what they observe is that the child came to the hospital in company of a mother or the police officer with a torn cloth or blood-stained cloth, and the medical officer describes all what happened to the child. Victor, you can continue now.
Thank you, Victor, for that. So you have discussed that the prosecutor should encourage investigation officers to use questioning that respects the right of a child. Then point number 7 is that the prosecutor shall, at the earliest opportunity, establish the special needs of a child in conflict with the law. Then number 8 is that the prosecutor shall establish from the investigative agencies if the child's parents have been informed of the arrest. Then number 9 is where the prosecutor shall establish whether prosecution and care file has been opened by either the children officer, the police officer, or the ODPP in respect of the welfare of the child in conflict with the law. Then we have practicable, a protection and care file, a social welfare report from the children, where practicable, a protection and care file should contain a protection and care form, a social welfare report from the children officer, and where diversion or plea bargaining is being considered, a social inquiry report from PACS.
Plea bargaining is not encouraged for the children cases. Plea bargaining is not encouraged for the children cases. I don't know why they say that. Now, that's our point number 7. It's not number 7 or number 5, whereby you said that number 7, yes, number 7, the prosecutor shall, at the earliest opportunity, establish the need of the child in conflict with the law. You know, sometimes some children, whenever they see any party, they may scream, or they may be afraid psychologically, or they may cry, or they may fail to speak. So the prosecutor must establish that at the earliest opportunity, mark earliest opportunity, the earliest stage. So that means the prosecutor, the children officer, the probation officer must be keen at the conduct of the child. They must observe the conduct of the child during the court cycle. Because sometimes a child in conflict with the law may see a witness and the child start crying. Yes. So just want to bring it into the attention of that. So the case of the Pascal report, I've told you. Now, there's a part where the children officer have to bring the social welfare report. The social welfare report in this case means the social inquiry report. So these are the parallel investigations which are being conducted by the children officer with the legal reports.
Wow.
Yes.
Thank
So
you,
whenever
Victor.
the child legal officer carries out his representation, the children officer, on the other hand, have to bring his submissions to the courts. So they are mainly there for the best interest of the child, for the benefit of the child. All those parties outside the party there, we have the children legal officer, the child legal officer, the child advocates, you have the prosecutor, you have the children officer, and the probation officer.
Wow. Victor, that is well captured. So in the Utumishi girls situation, we can say before the prosecutor decided to charge the minors, the prosecutor obtained, person to explanatory point number 4, the prosecutor obtained a child officer's report that was used to inform on whether or not the plea bargain or divert or charge the minors was to be considered. Then, if you read explanatory point number 5, we can also appreciate what data that is being encompassed in this children officer's report. They state that it should include the biodata of the child, contact of the reporter, any special needs of the child, the mental and physical health of the parents, the need for continuation of a stable home environment, interaction and interrelationship with other members of the household, adjustment to the school environment and community, whether there is a pattern of domestic violence in the home, parental use of excessive discipline or emotional abuse, evidence of parental drug, alcohol or child or sex abuse, and any other recommendation. So the prosecutor cannot ignore to read the report that is coming from the children's office report. So that is a very good analysis there, Victor, with what happens in the ground. So the prosecutor shall proceed with making the decision to charge, notwithstanding the absence of any of these reports. So if there are no reports to be considered, the prosecutor still reserves the power to proceed with making the decision to charge. In prosecution-guided investigations, the prosecutor should ensure that due consideration is given to the dignity and the emotional well-being of the child, and that the rights of the child are observed throughout the investigation process, as Victor has duly notified us. Before making the decision to charge, the prosecutor shall review the case files to ensure that the case is comprehensively investigated and adequately prepared. All communication to the investigating officer should be in writing and records are kept. So that is what entails the pre charge stage, and but in particular the investigations part. Then we move to the confessions part. The prosecutor shall support the court to establish if a confession meets the basic requirements for confessions. The prosecutor shall support the court to establish if a confession was procured freely and voluntarily, pursuant to Article 49(1)(d) of the Constitution of Kenya and Section 186(d) of the Children Act. The prosecutor shall establish if at the time of making the confession the child did so in fear of unknown consequences, or if there was a suggestion of the possibility of imprisonment which may lead the child to a confession that is otherwise not true. Committee on the Right of Protection of the Child, or on the Right of the Child. General comment number 10. While considering how a confession was secured, the prosecutor must take into account the age of the child, the education and exposure level of the child, whether the child understands the implications and consequences, whether the parent or guardian or legal representative was present, and the circumstances surrounding how the confession was secured. Then when a child makes a confession, the prosecutor shall caution the child, the parent, the guardian or legal representative on the meaning, implication and consequences of the confession. A prosecutor should consider the case for diversion if a child confesses to an offense. This, however, will be on a case-by-case basis. So, Victor, maybe this diversion is a technical term. What do you mean by diversion? Whether you have come across it? Then the guidelines, as Victor or anyone else tries to research on the same, then the guidelines still provides the use of initials. The prosecutor shall ensure that the name of the child, identity, home, or last place of residence and school, and particulars of the child's parents or relatives, and any other information that may disclose the identity of the child is not revealed by using initials in the charge sheet and by any other public document, including statements and publications. Then the age of the child is also to be considered. The documents used for proof of age includes any of the following: a birth certificate, birth notification, baptismal card, clinical card, and or age assessment. This is where the prosecutor shall determine the age of the child at the earliest opportunity. The prosecutor must ensure that the investigating officer provides all the necessary documents to establish the child's age before approval of the charge. Where there is no proof of age by birth certificate, then any documents such as school reports should be accepted and considered genuine by the prosecutor unless there is proof to the contrary. Where the question of age still remains unascertained, the prosecutor may invoke Section 143 of the Children Act for the court to make a determination on the age. Okay, that is very critical. In case of conflict or inconclusive evidence, the child shall be given the benefit of doubt, pursuant to Section 14(2) of the Penal Code. The prosecutor shall ensure the charge sheet indicates that the suspect is a child. So whenever we were drafting the charge sheet and giving these counts, we should have indicated that the suspect is a child. Where a child who has not attained the age of criminal responsibility commits a felony, the prosecutor shall make an application for the court to open a P&C file. Okay? Where the child in conflict with the law has attained the age of criminal responsibility but is below 12 years, the child shall not be held criminally responsible for an act or omission unless the prosecutor proves the child had capacity to know the act or omission was unlawful, pursuant to Section 142(2) of the Penal Code. Okay, so these are the tests that they are going to use when it comes to the Utumishi fire tragedy. Making the decision to charge. The prosecutor shall establish whether the child has attained the age of criminal responsibility, pursuant to Section 14 of the Penal Code. The prosecutor shall always consider alternatives to prosecution. While making a determination, the prosecutor shall also be guided by the ODPP decision to charge guideline, the ODPP diversion guidelines, the ODPP plea bargaining guidelines, and any other relevant ODPP policy documents, and the evidence contained in the police file and protection and care file. The prosecutor shall be guided by the general international guiding principles of the child justice, and in particular, the principle on the best interest of the child. And then the prosecutor shall ensure that the charges being preferred are proper, and once presented with the investigation file, the prosecutor shall establish if the rights of the child have been upheld by inquiring the following: whether the child had been detained, if the child was held separate from adults, whether the child had been kept in safe conditions, whether the child had been detained for more than 24 hours in police custody, whether there was mandatory initial contact with the guardians or parents after the arrest of the child. So it is mandatory initial contact. Whether the child had legal representation and or parent or a guardian present during any interview, and whether a children officer was present in a case where a child's parent or guardian was not traced for them to be present during the child's interview. This is provided for under rule number 4 of the Child Offender Rules, pursuant to the 5th schedule of the Children Act. The prosecutor should ensure that any communication to the investigating officer is in writing and that the records are kept. The prosecutor shall establish from the investigative agencies if the special needs of the child have been met. And while making a decision to charge, the prosecutor should also explore and identify a variety of dispositions, programs, and alternatives to institutional care that are available to the child. And the prosecutor should make appropriate referrals and follow-up mechanisms for purpose of diversion, plea bargain, rehabilitation, and reintegration. The prosecutor should ensure that both the child in conflict with the law and the parent or legal guardian are informed about the charge and the possible consequences in a manner that they can understand. This is pursuant to the Committee on the Rights of the Child, General Comment number 10. The prosecutor should actively involve the child, the parent, guardian, or guardian ad litem or legal representative in the decision-making process at the pre-charge stage. The prosecutor shall use the ODPP charge sheet. This is pursuant to section as annexure number 1 on the ODPP charge sheet. So there is an ODPP charge sheet that we will also have a look at when it comes to a charge sheet that is to be applicable when it comes to minors. Guidance on decision to charge. The prosecutor shall be guided by the provisions of the ODPP.
Before you move to the guidance, just go back to where you were. The deadline for that part, making the
decision to charge.
Now, the child advocate may be absent. The hero officer may be absent. All other parties may be absent. But the parent or the guardian of the child must be present, and mark that word mark. Whenever child is in conflict with the law, the first party, apart from the prosecutor, which is involved, is a parent or the guardian, and that one must always be present, even during the hearing, during the mention, the trial, all those things. The parent or the guardian must be present. And that is why when we started looking at this document, we mentioned the parent, we mentioned the prosecutor, then those other parties. The other parties in that case means the children officer, the counselor, and the probation and aftercare officer. So you can now continue.
Thank you, Victor, for that. And maybe to add on top,
schedule, I think the first schedule of this document, the first annexure of this document, provide the kind of the charge sheet is going to be used, and the charge sheet for the children and the charge sheet for the adults, that they are different. So that's the kind of charge sheet that you have. It is this one. So you know that the children are being tried in the children courts. They're being tried in the children courts.
I've lost the document. Yes. Let me open it. I've lost the document. So maybe, Victor, this was the charge sheet that the examiner was expecting.
Yes, that's why was explaining to you whatever I was explaining at the time. But for the purpose of the CLE, this structure, another one, the contents are the same. But also I'll be required to draft in that question the court you write in the children court at Milimani, at Nairobi, or Milimani, whatever. So you must mention the word children court. Yes, that is the judge sheet. So the children court of Milimani at Nairobi, then the case. But if the accused in that case was an adult, then it's not going to go to the children court. So remember that.
So, Victor, in this situation, maybe to interject in a little bit, did the examiner expect to see two different charge sheets?
I've said that if the accused is a child, then he or she will be tried before the children court. If it's an adult, is going to be tried before the normal courts. Now, the number of charges you are asking, there's no way whereby two charges are going to be read before the courts to the accused in the presence of the victim. So the charges you are being required to have is this one, which you have just projected. Now, if you look at that charge sheet, if you look at that charge sheet, we have the court station there, P and CR, that is post notation and care number. So instead of the CR number, the case number, we have that number there. Then application for an order at the section of the section. You have that. You can scroll.
But Victor, I also have a question.
This one, whatever you're presenting here, yes. This post-care report. It's a part which you have the charges.
It was guiding me to annexure number one. That was the charge sheet pursuant to the children.
There's a charge sheet.
On its own, Victor, no. It was getting me to annexure number one. I can confirm. And annexure number one is this one.
I look for the charge sheet and give it to you. But the charge sheet look like this one.
Now, Victor, I also have a question. The question paper that we were analyzing, it had one minor being the accused person, and an adult as the co-accused person.
The co-accused person. What did the
is that the position?
Provide? Do we charge the minor with the adult?
Good. There are provisions in this section CPC.
Yes.
That allows for consolidation of charge, joinder of parties and charges. Can you join?
I want to charge the adult and the minor with the minor.
There are some situations where the minor can be charged together with adults if the minor participated in the same facts and particulars of the same offense together with the adults.
Now, which section is that? And then,
yes,
was the age of the minor culpable for that offense?
17 years.
Then we can consider that.
He was capable.
We can consolidate that. Yes.
We can.
But again,
yes.
There are some things which we ought to look at during the pre-trial issues. And these issues involve what is known as the age assessment. We may be assuming that the child is 17 years and that child is around 18.
True.
but I will confirm, then inform you.
Okay,
Yeah.
thank you. Because that was arising in the pre-trial issues on the question C of the
Yes.
same. It was testing on pre-trial issues. So age assessment will also apply to the minor who is the victim or who is the accused person here. Thank you for that. Okay. Oh, Victor, now I get you. So this is what you are trying to say. Aya. Kwani mimi nilikuwa nasoma wapi wale? Nilikuwa nasoma next year marked 2. Is it visible?
Yes.
So
This is the one I was telling you.
So the examiner expected this document to apply on the Alex who is 17 years old.
It is not the whole of
The charge
it
part.
is not the whole document. It is the
Here.
charge part. And now the parties at the headline. Republic of Kenya in the children court. About the children court, then we have charge, defilement. Then you see that the parties, particulars of the offense, JM, the one I was telling you, JM on 22nd day off. Remember our question that was on the evening off. So here we have to be specific. On 22nd day of December 2030 at Kabati area, is the area, Kabunkuni sub-county, is the location. Kabati is the region, then Kabunkuni sub-county within Nairobi County. Now, remember, if you have read the comma, or we introduce the comma in the passage is not required, then you are going to know the meaning of the whole sentence. So you have to complete it where it's required and where it's necessary. Now, intentionally and unlawfully caused, the object used now, caused, is genital organ. You see that? So if it was a robbery violence, you could say could be porn, namely a machete, an armor. You see that? So you name the object to penetrate. Penetrate. What that object does? Penetrate the genital organ, namely vagina of the other child. Now, the other child is NM. Now, Victor, you allow me to ask you this.
Yes.
If a child like this one, but the victim is 15 years, the victim is a girl. If the accused is 12 years, what will happen? Or you can say, if a victim is 16 years and the accused is 12 years, what will happen in that case? Whom are you going to charge?
There is a latest decision.
Now, or I could love this way. When can defilement occur?
Defilement occurs where one of the parties is an adult.
One of the parties is an adult.
And the other is a minor.
So for that scenario, it's an adult, 16 and 13.
16 and 13, they are not adults.
But
they are minors.
Is that defilement in that case?
That is not defilement.
Under which provision now?
Pass on to the recent decision.
You remember that?
Yes.
Now continue, Victor.
Okay, thank you, Victor. So, I was still scrolling this document because we have now started going now to the critical aspects when it comes to the criminal litigation in affecting children. And we were at the investigations. part. Okay. Pre-trial. Okay, sexual offences, guidance. I think we were here. Yes, we were here. Guidance on decision to charge, we had. Yes. The prosecutor shall be guided by provisions of the ODPP decision to charge guidelines. And the prosecutor shall ensure that there is sufficient evidence available to provide a realistic prospect of conviction, what we call the evidential test, and that the interest of fair administration of justice will be served by prosecuting the matter through the public interest test. So the prosecutor shall exercise discretion as to whether there is public interest in the case being prosecuted, like the Utumishi girls. This decision shall be guided by the principle of the best interest of the child, taking into account the information contained in the P&C file and any social inquiry report available. But Victor, maybe for the benefit of doubt and to avoid any confusion, in the scenario that was posted before the students, question number 1, because we have been told there are provisions that allow for joinder of parties and charges, then age 17 and 19 could actually have been merged. Then the examiner could have expected only one charge with the various parts on the counts, maybe to avoid any confusion. Will that have been available? Because I was relying on section 135 and 136
What does that section provide?
of the CPC.
What does that section provide? The child was a victim. The child was an offender.
The child.
So you want to change?
Okay. Oh, no, Victor, maybe because you joined us when we had already read the facts.
Yes.
Ben was a 19-year-old Form 2 student. Ben was the one who defiled the minor. But Alex was an accomplice who was 17 years of age, still a minor. Okay? So in this situation is where we are saying that the CPC have granted a situation where we can have a joinder. The angle that I was saying that the law allows where an offense has been committed when a minor is in an accompaniment of an adult, then you can have joinder of counts and persons. Was that right? Was that the correct procedure?
I will come back to you. Let me confirm.
Okay.
I'm still doubting. When can we join the counts and the parties? Then two, can we join the parties who their ages, their capacities are different? Yes, but I'll come with the answer in due course. If not today, maybe before we start the next paper, well, before we come to the next dissertation on the civil on the criminal, because it's a paper. I think it's 2021 or 2020. One of those years which have the same question. And, maybe to inform you that these questions they normally repeat themselves, because we have gone through several papers of several years. We found out that these questions they normally repeat with some cards being twisted, but the topics they normally set are the same. There's no year which has gone without them going back to whatever was provided in the previous years. Just like the question 1, it was there in 2023. When we go to the paper of 2023, we see it was also there in 2025. Yes. The question on the children.
Thank you so much, Victor. You'll confirm, you'll clarify on us so that we also determine that maybe it is that confusing element where many students lost the mandatory marks in that question.
Yes, I'll confirm. But what I'm very sure of is that most of the students lost the marks mainly or simply because of of drafting a document, then they place them to the wrong courts. They might have placed them to the chief magistrate court instead of
Okay.
the children court.
Okay. Let us leave that open for confirmation, Victor. Then we have instances where we have sexual offenses, like the question requires. We read the explanatory note number 8 before you. Am I projecting my screen? My screen, is it visible, Victor? Okay, let me now it is moving. So higher. So section 8 of the Sexual Offences Act makes it an offense for a person to cause penetration with a child. However, there are cases of consensual sexual relationships between minors which have been termed as Romeo and Juliet cases through judicial precedents.
That one, 881 of the Sexual Offences Act, which makes which leads an offense for a person to cause penetration with a child. However, there are some consensual relationship, the consent. Judge Part was also asking if a child consent. The consent is altered, and that you had answered that. So, will that again still, will that law, that section still also is going to be amended as per the court advice?
What is the name of the decision?
No,
Also
I'm asking the one you said, the recent decisions of the court.
Yes, it should amend this part. It is a recommendation to the legislature.
It's fine. Continue.
Yeah, have I gotten it correct?
Yes.
The name of the decision, Victor, because for purposes of laws.
I'll refer, maybe again, I'll inform you. I've taken note of that.
Consensual. I'm also doing a quick search. If it fails to appear, then we'll end good. I'll also confirm of the same. It is not appearing from my end. So, now we were at the sexual offences part. The prosecutor shall not permit any plea bargain, pursuant to section 137N of the Criminal Procedure Code, out of court settlement or alternative dispute resolution in sexual offences where the victim is a child. That is where, Victor, you were stressing earlier. Then, the prosecutor may consider diversion in Romeo and Juliet cases if it is in the best interest of the child or children. This is where we found that the prosecutor now decides that I'm not going to charge, let's take the diversion route. In making a decision on a Romeo and Juliet case, the prosecutor shall pay careful regard to the following factors. 1. The relative ages of both the subject and the complainant and their levels of maturity, and whether there was a consent or use of any form of coercion or violence in commission of the act or any other relevant circumstances. And where a prosecutor makes a decision to take an alternative to prosecution, the same must be put in writing. So this is the part that we have said, pursuant to the recent decision, it will going to be amended, hopefully. Then victims of trafficking. The prosecutor shall ensure that no child victim of trafficking is charged for any criminal act committed as a direct result of being trafficked. Then cooperating child in conflict with the law. If a child in conflict with the law is cooperating, the prosecutor shall take the cooperation into consideration and exercise discretion in the best interest of the child. There is an explanatory note in that victims of trafficking in persons are routinely victims of enforced prostitution and other forms of exploitation. The prosecutor must consider that under Section 14 of the Counter Trafficking in Persons Act 2010, a victim of trafficking in persons shall not be criminally liable for any offense related to being in Kenya illegally or for any criminal act that was a direct result of being trafficked. Okay? So you can't impose criminal liability to a person who was being trafficked by saying that he was illegally in Kenya. Okay? Now, Complaints on violations of the rights of the child. The DPP has the authority to direct an investigative agency to investigate any allegation of criminal conduct. So where it is suspected that the rights of a child in conflict with the law have been violated, the prosecutor shall cause the complaint to be investigated and ensure appropriate action is taken. If it is suspected that a member of the National Police Service, security agency, or any other relevant government agency is responsible for violating a child's right, the prosecutor shall inform his or her supervisor and include the DPP in copy of all correspondence concerning the complaint. Where it is suspected that a child's rights have been violated, the prosecutor shall cause investigations to be conducted and take appropriate action, including but not limited to prosecution, referral to IPOA, IAU, Kenya National Human Rights Commission, TSC, or National Legal Aid and Awareness Program for further actions. Then we move to the pre-trial stage. These were now the question also demanded a student to be very critical in answering. Provision of legal representation. The prosecutor shall make an application that the child in conflict with the law is provided with a legal representative. The prosecutor shall ensure that any stage in the criminal justice process, the child in conflict with the law is promptly informed, appropriately advised, and receives legal representation as required by making an application to the court on the basis that the lack of legal representation may result in substantial injustice, pursuant to Article 52H of the Constitution of Kenya, as read together with Section 43(3) of the Legal Aid Act and Section 77 of the Children Act. Then the prosecutor shall make an application to the court for a parent or guardian to stand with the child in order to take care of the social needs of the child in conflict with the law. Appointment of guardian ad litem. The appointment of the guardian ad litem shall not be in lieu of legal representation. Where the child in conflict with the law does not have a parent or guardian, the prosecutor shall make an application for the court to appoint a guardian ad litem for the child. So that is mandatory, as Victor was stressing it out. This is provided for under Section 79 of the Children Act 2022. Okay, so alternative to prosecution and trial. While dealing with a child in conflict with the law, the prosecutor shall identify a variety of dispositions, programs, and alternatives to institutional care available to the child and recommend appropriate referrals and follow-up mechanisms for purposes of diversion, plea bargaining, rehabilitation, and reintegration. The prosecutor shall consider and be guided by the ODPP diversion guidelines, the ODPP diversion policy, the ODPP plea bargaining guidelines, and the bail and bond policy and all relevant laws before judgment. When considering alternatives to prosecution, the prosecutor shall be guided by Kenya's Constitution and all other enabling laws. Then diversion. The prosecutor shall consider and be guided by the ODPP diversion policy and guidelines. The prosecutor should be satisfied that a prosecution will be necessary should the offer of diversion be rejected, or if the child in conflict with the law does not complete the conditions set by a diversions agreement. Diversion may be considered as an appropriate response for all offenses committed by children, including serious offenses. While not all cases may be suitable for diversion, it should be the manner for dealing with the majority of cases involving children in conflict with the law. Diversion can be considered at any time from arrest to the close of prosecution case. A decision on diversion can thus be made either before or after a charge is laid. So the prosecutor shall consider diversion in all criminal cases involving children, pursuant to guideline number 35 of the ODPP diversion policy guidelines. Okay, so the prosecutor should make a decision on diversion as early as possible after a child in conflict with the law has been arrested. When considering diversion in the case of a child in conflict with the law, the prosecutor shall take into account the seriousness of the offense and the personal circumstances of the child, including the likelihood of reoffending, and like in any other decisions concerning children, the best interest of the child and their development needs will be of paramount importance. Then plea bargaining. The prosecutor shall consider and be guided by the ODPP plea bargaining guidelines. The prosecutor shall ensure that the plea negotiations are initiated at the earliest opportunity, and the prosecutor shall not permit any plea bargaining for offenses under the Sexual Offences Act, offenses of genocide, war crimes, or crimes against humanity, pursuant to Section 137N of the Criminal Procedure. The prosecutor shall ensure that the child in conflict with the law understands all the plea agreement terms. And then the prosecutor shall ensure that either the parent, guardian, or legal representative of the child in conflict with the law is present when the plea agreement is being concluded. Then let us look at bail and bond when it comes to these issues. The prosecutor shall be guided by the child offender rules and the bail and bond policy guidelines when making decisions on bail and bond for a child in conflict with the law. The prosecutor shall make a determination on whether or not to oppose a bail and bond application based on the special needs of the child in conflict with the law. Then let us look at pre-trial detention. We have been told by the question that one of the minors had been detained. What is the issue that will arise during the pre-trial? The prosecutor shall ensure that the pre-trial detention of a child in conflict with the law shall only be used as a measure of the last resort and in the best interest of the child, pursuant to United Nations rules for the protection of juveniles deprived of their liberty. The prosecutor shall ensure that a child in conflict with the law is not detained unless there are compelling reasons for the detention and that the detention shall be for the shortest time possible. This is pursuant to Article 53(1)(f) of the Constitution of Kenya and pursuant to bail and bond policy guidelines. So, the prosecutor shall ensure that a child in conflict with the law is not held for more than 24 hours without leave of the court. So, you need to request for leave pursuant to Article 49(1)(f) of the Constitution of Kenya and Rule 4.1 of the Child Offender Rules pursuant to the 5th Schedule of the Children Act. Okay. The prosecutor should not seek an order for pretrial detention of a child in conflict with the law where there is no real prospect that the child will receive a custodial sentence. Then when making a decision to request pretrial detention of a female child in conflict with the law, the prosecutor shall take into account their gender vulnerability, including inter alia the availability of gender-specific officers and cells. So these are the things to consider in the pretrial when utumishi girls are facing pretrial stages. The prosecutor shall ensure that the victim's views are considered in deciding whether to seek pretrial detention. Where it comes to the knowledge of the prosecutor that a child is detained with adults, the prosecutor shall bring it to the court's attention for relevant orders. And then the prosecutor should liaise with the relevant professionals in the child justice system and based on the advice or reports, make an application to the court for the child to be committed to the most suitable institution. Because pretrial detention should also be in principle not be applied for misdemeanors. Pretrial detention should also in principle not be applied for misdemeanors. Pursuant to explanatory note number 17. Then we have the pretrial conference. The pretrial conference states that the prosecutor should conduct a pretrial conference for the purpose of preparation for the trial in order to improve the quality of the trial, and that the prosecutor should ensure that all pretrial conferences are undertaken in the appropriate manner in accordance with the ODPP decision to charge guidelines. Then, whereas it is not mandatory for the child in conflict with the law to attend, the prosecutor shall determine who needs to be present at the pretrial conference. To inform in decision making, the prosecutor should ensure that they have all the information on the child in conflict with the law and the victim in the investigation file, including whether the file has complied with all the different laws and policies, and whether the evidence is sufficient, and whether the child in conflict with the law has a legal representative, and whether all the witnesses have been bonded. Okay, so for effective and efficient prosecution, the prosecutor shall ensure active case management of children matters by the following: having a duplicate investigation file in a white ODPP file jacket, maintaining a separate record of assigned children matters, ensuring a separate ODPP's children registry exists at each court station, informing the IO of the hearing dates, and supplying copies of statements and exhibits to the defense. Then the second part applies to the trial stage. This is the third part. Application for priority hearing. At plea taking, the prosecutor shall ensure that cases of children in conflict with the law are heard expeditiously by making an application for a priority hearing. The prosecutor should comply with the timelines as set out in the child offender rules, pursuant to Rule 12 of the same. There is little point in conducting a trial for a child offender long after the alleged commission of an offense, as the child will find it increasingly difficult, if not impossible, to relate the procedure and disposition to the offense, both intellectually and psychologically. That is the rationale of why you have to do an application for priority hearing. So whenever you're asking orals, you assume the shoes of a prosecutor. Kindly guide the panel on the various aspects that you will consider, both at the investigation part or the pre-charge, the charging part, the arraignment part, and the trial stage part. Sorry, anyone who has raised his hand? Okay. So we can, Victor, you have unmuted. Okay, so we are still continuing on swiftly. Procedural requirements during trial. The prosecutor shall inform the court of the need for an interpreter or counselor in a timely manner. A prosecutor shall ensure that the child in conflict with the law and parent or guardian are informed of the right to legal representation, and that the prosecutor should liaise with the IO in making all necessary efforts to ensure the presence of the parent, guardian, or guardian ad litem or legal representative of the child in conflict with the law. And then the prosecutor should not proceed with plea taking if a parent, guardian, or guardian ad litem or legal representative are not present, unless the court rules or holds that it will not occasion substantial injustice to the child in conflict with the law, pursuant to Section 4 and 76 of the Children Act. A prosecutor shall make an application to the court that a case involving a child in conflict with the law be heard in camera to ensure that the rights of the child are protected. Then disposal of cases, the prosecutor should encourage restorative justice. Then where restorative justice measures are considered, the prosecutor shall inform the child in conflict with the law, the parent, the guardian, etc. of the available restorative justice programs. Then what is the role of the prosecutor in disposal of cases? The prosecutor has the responsibility to assist the court in arriving at a decision as to appropriate disposal by making submissions which will draw the court's attention to the following: any victim impact statement, any statutory provision and case law relevant to the offense under consideration, any relevant aggravating and mitigating factors, and the need to call for a probation officer's report and a children officer's report to guide the disposal of the case. This is pursuant to Guide number 66 and 67 of the ODPP Diversion Policy Guidelines. In all children cases, the prosecutor has an obligation to draw the court's attention to its disposal options. Where practicable, the prosecutor shall make an application to the court for the attendance of a parent, guardian, or guardian ad litem or legal representative during disposal. And then the prosecutor shall not use the words conviction and sentence in relation to a child in conflict with the law, but a finding of guilt and an order upon a finding of guilt instead. Okay, so even the wordings should be analyzed carefully. Then you have the post-trial stage. So the prosecutor may urge in revision, the prosecutor may urge the court to review its own order if it's in the best interest of the child, and then the prosecutor may invoke the powers of the High Court to call for and examine the record of any criminal proceeding before the subordinate court for the purposes of satisfying itself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of any subordinate court. Then you have the appeal. The prosecutor, if not satisfied with the judgment, ruling, or order or sentence, may appeal to a higher court against such judgment, ruling, order, or sentence, or matters of law and fact. So I believe up to that part, we have directly looked at the procedural aspects that emanate from this part.
So looking at all that document, I think up to that part we have mentioned what is important. And again, if you look at the document mentions 3 things. One,
Okay.
the principles on the trial of or prosecution of the children. 2, the best interest of the child. And 3, prosecutor. Those are the main things which all of this document mention. again, looking critically, the other factors which the document mentioned on the children officer, foundation officer, the investigating officer. So we ought to understand the role of those parties in the criminal justice system, specifically the prosecution of the children. And the prosecution of the children in this case are the children who are in conflict with the law, the children who have been involved in the commission of criminal offenses, the children who have done contrary or have conflicted the law. Now, with what you are going through in all of this document, I think, Victor, you can share the document in the group. It's going to help us.
Yes.
As per the question, all the question papers I've gone through, I think we have answered most of the questions which have been tested. I was trying to count that we have 17 questions which this document have answered. And remember that this document has the provision of the law and rules and regulations which guide in supporting the answers. When you're going to look at the other papers, from the year 2015 to 2026 April, we'll find that this document is going to be of importance. And again, the current case on Utumishi, as per what is trending, and the advice of the criminal litigation instructors, it's not going to miss the oral or CLE exams. Yes.
True.
So, Victor, I was still praying that you share this document. It's very important.
Once I finalize recording my screen, because when I'm sending the document, I must also access my WhatsApp and it will be shared online. So I purpose, I undertake to share the same immediately after the presentations.
Now, finally, on my submission, with that, I think we about the last part of the course outline. I don't have the course outline with me here, but in the course outline, we have tackled a full topic on the issues of the children, and the special is a topic on the special. It was called special something special on the trial or whatever, which has to do with the children, the corruption offences, and the others. I think topic number 18. We have the supply look at that in the last part. And also with this question, we have handled the subtopic on the trial process. The last part of the trial process, which involved the trial of the children who are in conflict with the law. So we have killed two birds at the same time. The subtopic on I think it's 9 or 10. And there's a full topic on special trial of children. The topic which in the course outline, which have the trial of the children, the trial of special categories of persons, children, innocent persons, and those other parties which require the parties admitted. You can remember the last part of the course outline, which will come in term 3. But what is important in this case, you look at all the other papers, is drafting. Drafting means we cannot look at that, it carries out of marks. Out of, if it does not come, if it's not going to come in question 1, if it comes in question 2, then all of that drafting, whether it takes 7 marks or 6 marks. And remember that we are looking for 30 and above. If it's 30 and above, we already have the 6, or if it was 10 marks, we already have the 6, which is more than half. That can take us even to 40. I don't think I have another issue. Maybe we can come back to whatever we were looking at, not unless
Okay.
there's another person in the meeting who can who have something to raise concerning the same thing. Back to you, Victor. You can carry on.
Victor, that is well captured. I didn't know that we were doing a whole unit, a whole topic over the same. So that is a very good
Victor,
sign there.
That if we deal with this question papers comprehensively daily at the appropriate time, you may find out that we are talking around 3 or 4 topics. Like yesterday, we along with the criminal litigation paper for the year 2025. I think it was question 1 or 2, which are the issues of revision, appeals, trial. 30 marks. So 30 marks or 30 marks somewhere. Then analyzing on that, we dealt with 3 topics ago. When you're looking at the civil litigation paper for the year 2025, question 1 and question 2, it covers 5 topics. Looking at the memorandum of appeal, notice of appeal, notice of motion, and affidavits, which we were supposed to use. So I remember when we looked at the question number 2, someone raised a question on the documents you are supposed to draft. Then the first document was the notice of appeal. Then the second document was supposed to be the notice of motion with supporting affidavits or memorandum of appeal with verifying affidavit. And we just want to looking at the trial process in civil litigations. Trial process covers around 3 topics. Without knowing that, we answer around 3 questions in the 2020 paper, and around 3 questions in 2020 paper, and questions in 2016 paper, and question in 2015 paper. If you look at all across of those papers, there's no unit which is not being repeated, but with the thing that is being twisted. So, still advising that we go through the paper. If you have any doubt, we refer to the course outline and reference materials which guide us on this. Not unless you have any other comment on whatever I've submitted, I pray to submit before you my opinions on that.
Victor, that is well captured. On my end, I don't have any additional point. I have greatly appreciated your insight, together with the various analysis of the various papers that you have conducted, and the fruitful discussion that you are proving to have. Then I will resort back to question number 2, if there is no objection to the same. Let me project question number 2. So on question number 2, I believe it is visible. So the person who scanned these documents scanned them the way it is appearing before your screens. So David is a disturbed man. His only son Yusuf is accused. Okay, let me reduce the size so that you can see, enlarge a little bit. So David is a disturbed man. His only son Yusuf is accused of murder contrary to section 203 as read together with section 204 of the Penal Code. The son is held at Kibera Police Station since Saturday, 12th May 2025 under OB number 6212-5 of 2025. Brief circumstances of the case are as follows. That on the 25th April 2025, a team of young boys, students from Uzalendo Rescue Center in Kibera, Majengo slums, asked for permission from the director of the rescue center to visit the main shopping center for preparation of their birth certificates, in preparation of their school opening the following week. While at the shopping center, Yusuf, being the accused, Victor, you have unmuted. It is, yeah, thanks. So while at the shopping center, Yusuf, the accused, in company of 4 other young men at Majengo slums, are said to have confronted the rescue center boys, attempting to rob them of their phone and money, charge from the cyber cafe. The rescue center boys managed to disentangle themselves from their attackers and ran towards their rescue center through the Majengo main road. The attackers, led by Yusuf, followed them, chanting "Mwizi, Mwizi, catch a thief." Unknown to the happenings at the shopping center, another student, Bahati Mpole, left the rescue center at 1845 hours to see a friend at the shopping center. He used the same main road from Majengo to the shopping center. After about 500 meters, he met with 2 of his colleagues running toward the rescue center. They tried to wave him back to return and follow them, but he could not understand why they were running away. Just before he could turn back, the team of young men from Majengo slums arrived, led by Yusuf. Bahati Mpole could recognize him very easily, having known him from the bus terminus at Rongai. He could also recognize his voice. He heard Yusuf shout to the other boys, "Huyu ni mmoja wao. This too is one of them." The slain young men attacked Bahati Mpole with fists and stones and left him unconscious and bleeding profusely. In the meantime, the young men who had rushed to the rescue center alerted the other center boys and their director of what had happened, and that they had the slum boys indicate that Bahati Mpole was one of them and could be under attack. They also rushed to the scene where they found their colleague in a bad state. They helped the director to place Mpole in his car to Mediplex Hospital located in Kibra sub-county, and they pursued the slum boys, where they were able to arrest Yusuf along Majengo Road. Bahati Mpole was treated and later referred to Kenyatta National Hospital for CT scans and specialized treatment. The investigating officer at Kibera Police Station recorded statements from all students at the rescue center, as well as from Bahati Mpole from his hospital bed, who was able to inform the IO that he could recognize Yusuf as the person who led the Majengo youths. On the 10th day of May 2025, Bahati Mpole unfortunately passed on, and on the postmortem examination is yet to be conducted. Most of Mpole's colleagues at the rescue center are high school students, and footage at the Mkulima Call, where the confrontation began near the bus stage, is also yet to be retrieved. Additionally, the director of the center, Julius Weldon, is also away in Germany on invitation by the donor supporting the rescue center. The rescue center youth have vowed to retaliate in the event the accused is released by the police or the court. As a prosecution counsel, draft the substantive legal document for miscellaneous application seeking for 7 days custodial of Yusuf pending the completion of the investigation, and the question carried 10 marks. So basically, all of the story was directing you to draft an application seeking extension of 7 days to conduct investigation. So the heading is that the Republic of Kenya, in the Chief Magistrate Court at Kibera, criminal miscellaneous application number Republic versus Yusuf being the accused, application under section 36A of the Criminal Procedure Code for extension of custody or remand pending completion of investigations. Take notice that this honorable court will be moved on this date at this time in the forenoon or soon thereafter as counsel for the applicant may be heard on the following prayers: that this honorable court be pleased to certify this application as urgent and grant the same in first instance. That this honorable court be pleased to grant an order extending the custodial remand of the accused Yusuf, currently held at Kibera Police Station under Obin, this for a further period of 7 days from the date of this order, to enable the completion of investigations into the offence of murder contrary to Section 203 as read with Section 204. That the cause of this application be provided for, which application is based on the following ground. So these are the grounds that the examiner will look at. The accused was arrested and is currently in lawful custody at Kibera Police Station in connection with the death of one Bahati Mpole, and that investigations into the matter are still ongoing and incomplete. The nature of the offence is grave, being murder, and the evidence so far links the accused to the commission of the offence. Further specific inquiries are necessary, including post-mortem examination, retrieval of the CCTV footage, conduct of an identification parade, recording of additional witness statements, including from the director of Uzalendo Rescue Center, who is currently abroad, and compilation of a comprehensive file for charging. The release of the accused at this stage will prejudice the investigations and pose a real risk of interference with witnesses and evidence. Given the tensions in the community and threats of retaliation by the deceased colleagues, it is the interest of justice that the accused be remanded in custody for the limited period sought to allow proper investigations. So key takeaway is you are approaching court through a notice of motion, and the application is being is getting its powers from the Section 36A of the Criminal Procedure Code. Then you have to attach a supporting affidavit sworn by the investigating officer. So, and basically, if you could have drafted that one, you could have scored the full 10 marks. So the other question we have, question 3. Lucky was recently declared an interest, who has recently declared an interest to vie for the position of governor in Utopia County, has gained prominence amongst young voters due to her support of the Gen Z-led protests that were recently experienced in the country. This support has equally earned her enemies. Some of her key supporters were recently arrested and arraigned in court for charges of incitement to violence and destruction of property. Lucky has spoken out against this arrest and alleges that they are meant to intimidate her. She particularly points out the fact that Utopia County Police Commander, who is the brother-in-law to the serving governor, is behind the arrest. The county commander has also been accused of being behind abductions of the governor's political opponents in the past. Recently, violent protests erupted outside the county headquarters when a group of protesters gathered to demand the resignation of the governor for what they termed as mismanagement and gross incompetence. In a press conference later that day, the county commander vowed to crush the rioters and their chief founder Lucky. Upon making these remarks, more of Lucky's supporters and close family members were rounded up and detained in different police stations across the county. Lucky, who has been on a tour of the United States of America, has been informed that the police are looking for her and they have been seen camping outside her residence. She is due to return to the country in 3 days' time, but is apprehensive that her rights might be violated. Prepare the necessary pleadings for filing in court to protect her rights. So in this situation, she has realized that she is being looked after by the officers. Okay, so what document will you use to approach the court? You are approaching the court through a constitutional petition in the Republic of Kenya, in the High Court of Kenya at Nairobi, Constitutional and Human Rights Division, that carries a mark. Petition number this, Lucky being the petitioner, versus the DPP, the IG of police, the Utopia County Police Commander, the Attorney General, and IPOA. Petition under Article 22 and 23 of the Constitution of Kenya 2010 for redress of violation and threatened violation of fundamental rights and freedom. The humble petition of Lucky shows, so you now summarize what entails a good structure of a constitutional petition. So you have the particulars of the petitioner, who is Lucky. Then you describe the particulars of the respondents. Then you describe the facts. Then you discuss the violations and threatened violations. Okay, in this situation, you have Article 29, freedom and security of the person, right not to be arbitrarily arrested or detained, not to be subjected to any form of violence or threat. Then Article 27 on equality and freedom from discrimination. Then Article 33 on freedom of expression. Then Article 37 on freedom of assembly and association. Then Article 38 on political rights, on right to participate in political activities and seek elective offices, and Article 47 on right to fair administrative action. And lastly, Article 50 on fair hearing in the event of any prosecution. Okay, then you must finish with the reliefs being sought. So amongst the relief that you'll be seeking is a declaration that the respondent's action and threats against the petitioner violate her rights under Article 27, 29, 33, 37, 38, and 47, and 50 of the Constitution, and that you are seeking a permanent injunction restraining the respondents and their agents or servants from arresting, detaining, harassing, abducting, or in any manner interfering with the petitioner's liberty and freedom of movement, except upon lawful and reasonable suspicion of having committed a cognizable offense and in strict compliance with the law. That an order be issued against the second and third respondent to provide the petitioner with adequate security protection upon her return to the country. That an interim conservatory order be issued pending the hearing and termination of this petition, and an order compelling the fifth respondent, IPOA, to investigate and conduct of the third respondent in this matter. However, some decisions have said that you cannot use application and reliefs pending arrest to frustrate the investigating agency's mandate. Some courts have even proceeded to give conditions, conservatory orders with conditions that you avail yourself within 7 days to the investigating agencies. Okay, so there is a rider. For urgent interim orders, you can file a notice of motion. This can be filed alongside the petition seeking immediate conservatory orders under Article 23(3)(c) of the Constitution. This petition is the most appropriate and comprehensive legal document to protect Lucky's rights preemptively. It can be filed urgently, and the court may grant interim protection orders ex parte if a strong case of threatened rights is seen. Okay. So, question 4. Nyamo and Omwambi were jointly charged with and convicted of the offense of trafficking in narcotic drugs contrary to Section 4(1) of the Narcotics, Drug and Psychotropic Substances Control Act No. 4 of 1994. The proper provision should have been Section 4A, as Section 4(1) does not exist in the Act, for having allegedly been jointly found transporting 2,071 stones of cannabis sativa with an estimated street value of 400,000 in a contravention of the provisions of the said Act. They were each sentenced to an imprisonment term of 7 years. Aggrieved by their conviction and sentence, they lodged a first appeal to the High Court. The land judge of the High Court dismissed their appeal against conviction and set aside the sentence of 7 years imprisonment. The judge then enhanced the sentence to a term of life imprisonment in addition to a fine of 1 million. In setting aside the term of 7-year imprisonment, the land judge expressed himself thus: The learned trial magistrate sentenced each appellant 7 years imprisonment without a fine. This sentence was irregular as the street value of 410,000 was not proved by expert evidence. The minimum fine of 1 million should have been imposed by the trial court upon conviction. The appellants should also have been sentenced to imprisonment for life. The appellants are further aggrieved by the judgment of the High Court and intend to appeal to the Court of Appeal. You work for MS, B, and B advocates, and you have been handed the instant brief. Citing the relevant legal provisions and case law, analyze the jurisdiction of the Court of Appeal in appeals of the nature depicted in the set of facts, and draft the relevant pleading, noting to highlight at least 2 possible grounds of appeal. So basically, this question was testing a student's mastery of the appellate procedure when it comes to the criminal cases. Something needs my attention. Stay in the corner. Okay. So we start with first understanding the general provisions that guide this situation. So we start with the jurisdiction of the Court of Appeal by hearing second of appeal on our facts alleged. So the Court of Appeal can hear the intended appeal only on points of law, but it has jurisdiction to interrogate the legality of the charge and legality or propriety of the High Court's enhancement of sentence. It cannot re-evaluate pure facts or argue severity as a factual complaint. Governing provisions we have: second appeals are confined to matters of the law pursuant to Section 361 of the Criminal Procedure Code, and in particular, severity of sentence is treated as a matter of fact generally not appealable on second appeal, but illegality and unlawfulness of a sentence is a point of law. Okay, so severity of a sentence is treated as a matter of fact. So you can't appeal on severity of a sentence all the way to the Court of Appeal. Okay, but illegality and unlawfulness of sentence is a point of law. Then appeal from High Court to Court of Appeal, including on conviction as of right and on sentence with leave unless fixed by law. Okay, appeal from the High Court to the Court of Appeal, including on conviction as of right and on sentence require leave unless fixed by law, pursuant to section 379 of the Criminal Procedure Code. So key takeaways we have: second appeal, you only appeal on points of law only. And the decision on Caroline Auma Majabu versus Republic 2014 reaffirms the section 361 limit, that sentence interference only where legality and principle is in issue. Okay, so no jurisdiction where appeal is sentence only and raises no point of law. That is it. Now application to facts. Miscitation to section 4.1 being non-existent is a legal defect going to the validity of the charge and conviction. The Court of Appeal has jurisdiction to quash on that point of law. Enhancement from 7 years to life plus 1 million raises legal questions. Whether enhancement was procedurally proper, whether there was a notice of warning, and whether the High Court misdirected itself on the penalty under section 4A, e.g. treating it as mandatory. Those are points of law within section 361 jurisdiction. Then you have been told to draft the possible pleadings when you are now approaching the Court of Appeal. The Notice of Appeal, Criminal Division. In the Court of Appeal in the Republic of Kenya, in the Court of Appeal at Nairobi, criminal number this, between Nyamu, Ombi, and Republic, Notice of Appeal. Take notice that the appellants being dissatisfied with the whole judgment, including the conviction being upheld and sentence being enhanced of the High Court of Kenya at this date, before this honorable judge, delivered on this date in High Court criminal number appeal, intend to appeal to the Court of Appeal against that decision. It is dated and it is addressed to various parties. Then the second document that the examiner was looking for was the Memorandum of Appeal, highlighting the 2 grounds or more that will suffice in this appeal. So the appellants appeal to the Court of Appeal against the judgment of the High Court at this delivered on this. We rely entirely on the following grounds. 1. Defective or unknown offense provision being an error of the law. The learned judge erred in law in upholding a conviction founded on a charge framed under an unexisting statutory provision, namely section 4.1 of the Narcotics, Drugs and Psychoactive Substances Control Act, thereby rendering the charge and ensuring proceedings nullity. Then 2. Unlawfully enhancement or breach of fair process, error of law. The learned judge erred in law by enhancing the sentence on first appeal to life imprisonment and a fine of 1 million without complying with the legal requirements governing enhancement, including giving the appellants clear notice and an opportunity to address the court on the risk of enhancement. So it appears that before your sentence is enhanced, you must be given notice and an opportunity to address the court on the risk of enhancement. Then there is a misdirection on sentencing under section 4A on the error of the law. The learned judge erred in law in holding that the appellants should also have been sentenced to imprisonment for life and that the minimum fine of 1 million should have been imposed, thereby misdirecting himself on the proper interpretation and exercise of sentencing discretion under the Act. The reasons wherefore is that the appellants pray that the appeal be allowed, the conviction be quashed and sentence be set aside, and our own evidence be reviewed and substituted with a lawful sentence. And that's it. Then question 5. The Directorate of Criminal DCI, in collaboration with officers of Ethics and Anti-Corruption Commission, successfully investigated allegations of embezzlement of public funds and abuse of office against Mr. Ndovu, a first-term governor in Kenya. After reviewing the evidence, the ODPP directed the investigators to trace properties associated with Mr. Ndovu. In addition, the ODPP preferred an additional charge of acquisitions of proceeds of crime contrary to Section 3B1 as read with Section 61A. 9 of the Proceeds of Crime and Anti-Money Laundering Act. This was after the investigation established that Mr. Ndovu held a suspicious bank account at Alltops Bank, Kitengela, with account number that and the name of Ndovu Mapeleo, which received deposits totaling to 12 million within the first 3 months of his tenure as governor. At the conclusion of a 3-year trial, the governor has been convicted on all counts and sentenced to pay a hefty sum of fines. The court has further ordered that all properties and funds held in his bank accounts constituting the proceeds of crime be forfeited to the state. Mr. Ndovu's family has retained you to secure his immediate release and to lodge an appeal against his conviction and sentence. Citing relevant law examining the legal principles the court will consider in determining the application for bail pending appeal, and B. Advise the ODPP on the most appropriate immediate legal remedy available to preserve the funds in the said account pending investigations and further orders of the court. So generally, the examiner expects you to know how to draft an application for bail pending appeal, and where most appropriate immediate legal remedy that one can seek to protect or preserve the funds in said accounts pending investigations. So there are some key takeaways that you have to understand. Section 356 and Section 357(1) of the Criminal Procedure Code are the statutory basis for 1. Bail pending or stay pending the entering of an appeal, and 2. Bail or suspension of sentence of an appeal after an appeal has been entered. So governing provisions is that bail and or stay pending entering an appeal pursuant to Section 356 of the CPC. Then we have Section 356(1). The High Court or the subordinate court which convicted or sentenced may grant bail or stay execution of a sentence or order pending the entering of an appeal or reasonable terms, including security. Then Section 356(2). If ultimately liable to imprisonment, the time on bail or under stay is extended in computing the sentence term unless the court order otherwise. Okay, so it is excluded. The time that you are on bail or under stay, it will be excluded in computing the sentence term. 2. Where we have bail or suspension after entering an appeal, pursuant to Section 357(1) of the CPC. So Section 357(1) of the CPC provides that after the entering of an appeal, the High Court or the convicting or sentencing subordinate court may order the release on bail with or without sureties, or 2, if not released on bail, must, at the appellant's request, order that execution of the sentence or order appealed against be suspended pending hearing of the appeal. And provision is that if the subordinate court refuses bail, no further bail application lies to the High Court. Instead, the person may appeal against refusal to the High Court, heard by one judge in chambers. And then Section 357(2), if the appeal is dismissed and the imprisonment confirmed and substituted, time on bail or suspended sentence is excluded in computing the imprisonment term. Chief Justice may make procedural rules. So for bail and bond pending appeal in Kenya, the court applies a tight test. The applicant must show the following: that the appeal has overwhelming chances of success, and or 2, exceptional or unusual circumstances, plus 3, that the appeal won't be heard before a substantial part of the sentence is served. So these are the tests that the examiner will expect to see from a student. And the governing rule is that the power to grant or suspend sentence pending appeal is pursuant to Section 357 of the CPC. So what are the tests that you have to master? Overwhelming chances of success and strong appeal on a point of law. So the court will look at the record and judgment to see whether the appeal is plainly likely to succeed or not merely arguable. Then 2, you should have exceptional and unusual circumstances. Examples sometimes raised is where we have serious illness not manageable in custody, other rare circumstances, ordinary hardship, good character, being a breadwinner, or a well-trained court are not enough. Okay, so those are not enough reasons. Risk of serving a substantial part or role of the sentence being before appeal is heard. So this factor strengthens the case for bail, especially for short sentences or where the bail is likely or where the appeal is likely to delay. If the appeal can be fast-tracked, bail is less likely. Okay. So generally, we are still looking at the governing rules surrounding this part. So bail pending appeal is discretionary and is granted sparingly. The applicant must show either an appeal with overwhelming chances of success or exceptional or unusual circumstances, including likely completion of sentence before appeal is heard. Governing rule is where we have the court may release a convicted person on bail or suspended sentence after the entering of an appeal. Section 357(1) of the CPC. And if needed before entering the appeal, pursuant to Section 356 of the CPC. Overwhelming charges or substantial merit in appeal. The courts look at whether prima facie the intended appeal raises a substantial point of law likely to succeed. If not, there is little point in releasing a convicted person. Exceptional or unusual circumstances, e.g., serious demonstrated illness not manageable in custody, or other unusual facts justifying temporary liberty. Then you have application to these facts, what we must put in our application. Because Ndovu has been convicted after a full trial and sentenced a person to apparent fines and forfeiture orders, you must demonstrate by reference to the draft memorandum of appeal and record that 1. There is a substantial point of law likely to upset conviction and sentence, forfeiture, e.g., misdirection or amendments of the Pokamla count, admissibility weight or weight of the bank evidence, burden and standard applied, illegality of forfeiture order made in the criminal trial, and or exceptional circumstances strictly proved by affidavit and medical reports, and or if there is a custodial or default imprisonment exposure that is likely to serve a substantial part before the appeal is determined, otherwise the court will just order an expedited appeal. B. Immediate remedy to preserve the funds in the account pending investigations. Apply ex parte application or orders for Pokamla preservation or preserving order over the bank account and any related assets to prohibit any dealings pending investigations and subsequent forfeiture and other orders. Preservation order is provided pursuant to Section 82 of the Pokamla Act, where it has empowered the agency director to move the court for ex parte for an order prohibiting any person from dealing with property reasonably suspected to be proceeds of crime used in an offense with the similarly orders for seizure. If the matter is already within the criminal forfeiture framework, a restraint order is also available, pursuant to Section 68 of the Pokamla. So the practical steps that the ODPP will undertake: identify the proper applicant under Pokamla, who is the agency director, and file an urgent ex parte application citing that the account number and the funds deposited are the property to be preserved. Seek orders that they freeze and prohibit dealing, bank to preserve and disclose statements, and serve notice or directions under the Act. On grant, comply with statutory notice and publication steps for preservation orders so that the parties can appear, if any. Then move to the next step on forfeiture and other orders within the Pokamla Act scheme as advised by the evidence posture. File a notice of motion or chamber summons per station practice in the High Court for bail and bond pending appeal, and 2. Stay or suspension of execution of sentence and consequential forfeiture orders pending appeal. The statutory anchor was Section 356 and 357 of the CPC. And you plead the overwhelming chances of success, exceptional circumstances, and risk of sentence being served before appeal. So this is how it will appear. It is a notice of motion. You cite the enabling provisions, and then you state the grounds that we have discussed extensively. Then you will have the full marks, obviously supported with an affidavit in support. Then question number 6. Question number 6 says that Jabali was charged with the offense of robbery with violence contrary to Section 296(2) of the Penal Code on 10th November 1999, while in the company of 3 others and armed with pistols. They alleged to have robbed a priest of his vehicle and 264,000 in cash, and in the process killed the said priest and raped a nun. After a full hearing, he was convicted and sentenced to death on 11th April 2004. He appealed to the High Court on both conviction and sentence. The appeal was heard. The conviction and sentence were upheld. He filed a further appeal to the Court of Appeal, which was again unsuccessful. He had exhausted all appeals and remained on death row as at 2009. The Power of Mercy Advisory Committee considered his case and commuted the sentence to life imprisonment in 2018. While in prison, he attained skills in carpentry, was a trustee and representative of his CELT block, and has good recommendations from the prison authorities. He is now 53 years old and believes he has fully reformed. He wishes to file an application for review of the sentence. Citing relevant case law, trace the development of the law on resentencing in Kenya, and explain the options available to Jabali. 1. The examiner expected to see that the angle that resentencing aspects has developed over the years. So resentencing grew out of Muratetu, where we had mandatory death sentence for murder being declared unconstitutional. This was widely applied by lower courts to other capital offences, including robbery with violence. Then that was curtailed by the Supreme Court 2021 directions limiting Muratetu to murder only. Post 2021, resentencing for Section 296(2) requires a fresh constitutional challenge to that provision, or rather lawful avenue, but not a straight Muratetu resentencing motion. Governing rules is that Section 296(2) of the Penal Code provides for the robbery with violence penalty is still framed as death. So judicial interpretation and the timeline that the examiner expected to see for you to score the 5 marks. Post 2017, where the lower courts extended Muratetu beyond murder, the High Court decisions treated the logic of Muratetu mandatory sentence unconstitutional because it removes discretion as applicable to robbery with violence resentencing petitions. An example is that of Ibrahim Mduiga Mvungu versus DPP 2018. Okay. This held that Muratetu applies to Section 296(2) and ordered resentencing process. Then there is a divergence even before 2021. Some courts allowed resentencing but retained death as appropriate on aggravated facts. Others dismissed on jurisdiction and merit. An example is where resentencing considered but death upheld on facts, where we have Douglas Gitonga versus Republic. So these are the marking schema that the examiner expected you to have known. A note of the divergence, that resentencing was considered but death upheld on facts, like in that decision, Douglas Gitonga. So Supreme Court directions on clarification came in 2021 to clarify the angle that the other courts were interpreting this decision. We had Muratetu and another versus Republic, Katiba Institute and 4 others, Amicus Curiae 2021. These were the Supreme Court held that the Muratetu holding applies only to murder, pursuant to Section 203 and 204 of the Penal Code. It does not automatically extend to robbery with violence or other offences. And then post 2021, position in the High Court is that many resentencing petitions for Section 296(2) were dismissed and struck out for want of jurisdiction and merit if premised purely on Muratetu. The example of that is in the case of Issa Abdul Otiambo versus Republic 2021, where it declined Muratetu-based resentencing for Section 296(2). Okay. This applied to Jabali. Jabali was convicted under Section 296(2). This is a straight Muratetu resentencing motion that is now vulnerable because of the 2021 Supreme Court clarification limiting Muratetu to murder. Then the options available to Jabali. His realistic options are: 1. To file a constitutional petition specifically challenging the mandatory nature of Section 296(2) as unconstitutional, or pursue the clemency or mercy route further, where you have a simple sentence review or a sentencing application based on Muratetu is likely to be rejected post 2021. So the examiner expected you to cite the following: constitutional petition challenging Section 296(2) on mandatory death and seeking resentencing. Filing the High Court Constitutional and Human Rights Division and Criminal Division, seeking a declaration that the mandatory aspect of this provision violates fair trial sentencing discretion and consequential resentencing. You must plead and prove the constitutional questions directly, not to import Muratetu, because post-2021 courts insist on a fresh and properly framed challenge for non-murder capital offences per Muratetu directions of 2021. Then he will also consider mercy and clemency route administrative. He already benefited from commutation from death to life. He can still petition through the power of mercy process for further remission or commutation commutation on rehabilitation ground. This is discretionary but not a judicial review application. The practical note is that on sentence review in the criminal file, if he files a resentencing motion in the criminal cause without a new constitutional foundation, the court is likely to decline the jurisdiction that was advanced post 2021. So this was a very easy question for a student who followed up with the current jurisdiction of the country. So basically this paper was a bit technical, but was still confined to the course outline. So we can say that basically the paper was scored poorly because it involved aspects like we have seen question 1 where students were confused whether to draft a charge sheet involving an adult or a minor. Can you consolidate the same? So those were the dilemmas that students were faced with. So thank you for your participation as we embark to discuss the professional ethics that was done in 2026.